The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Well, welcome everyone. It is not currently too beastly hot in this courtroom, which is a nice change of pace. We have 4 cases scheduled for today, and let's just, I guess, get right into it. Our first case is number 226698, Yelizarov versus United States, or I guess United States versus Yelizarov, and I believe Ms. Skelton, you're first.
Good morning, Your Honors. May it please the Court. My name is Megan Skelton, arguing this morning on behalf of Stanislav Yelizarov. Mr. Yelizarov had a bystander, not a lawyer, when he was negotiating his plea. His counsel's performance fell far below an objective standard of reasonableness. There's essentially no dispute that his lawyer conducted zero investigation into the bombshell that the government dropped just days before he was set to enter his initial guilty plea. This was clearly not a strategic choice, and the consequences of his inattention are not entitled to a presumption of reasonableness. It is clear that even the government thought that this information would have an impact on whether Mr. Yelizarov wanted to plead guilty or enter the plea that he had. Otherwise, they would not have contacted his defense counsel just days before.
Well, what do we make of the fact that Mr. Yelizarov told him to leave it alone?
Well, that still is evidence of his conduct falling below an objective standard of
Doing what his
reasonableness.
client said.
Well, doing what his client said, Your Honor, I don't think his client actually said leave it alone. He said they can't prove it. They'll never get me. And that's really not something that an objectively reasonable defense counsel should accept. There should at least be some effort to have a second conversation, if not more. It makes perfect sense to have the first conversation, go away, get the information you need, poke around, come back, and at least have another conversation.
So do you agree with me that the Sixth Amendment right to counsel is offense specific? Hasn't the Supreme Court held the Sixth Amendment right to counsel is offense specific?
Yes, certainly it is charge specific.
And do you agree that the Sixth Amendment right to counsel does not attach until the initiation of formal proceedings?
Yes.
So can we agree that no matter what else is the case, this individual was not Mr. Yelizarov's lawyer in a murder case because Mr. Yelizarov had not been charged with murder and because he had not been appointed to represent Mr. Yelizarov in murder?
I will agree with Your Honor to a point on that. However, I don't.
Which part? Which point do you agree to?
I do agree that he was not his lawyer for the murder case, and of course a different lawyer was.
So any deficient performance then has to be in connection with the robbery
Absolutely.
charge. Okay.
Absolutely.
And so how is it ineffective in representing someone on a robbery charge who tells you they can't pin this murder on me to not investigate a murder charge in which you're not someone's lawyer?
Well, I think that all of the parties agreed, and the judge below certainly did as well, that the consequences of the plea had broader impacts, and of course the Supreme Court said that in Padilla, that the consequences of the plea could be collateral consequences.
Well, but sure, but that's a case in which, let's just continue with the robbery example. I'm representing an undocumented person in a robbery prosecution. If they are found guilty of the robbery, it may have immigration cases and so consequences. So Padilla said, but it will have the conviction on the count for which I represent them will have immigration consequences. But I don't understand how being convicted of robbery has consequences for the homicide charge for which he's not currently charged.
Judge Hazen, I don't think it is actually the conviction on robbery that we're talking about. It's the choices that he made with respect to his robbery charges.
Okay.
Because what was going to happen in the murder case, whether he would be convicted or acquitted or plead guilty or go to trial in the murder case, is a separate question. So I guess that's the part of your other question that I 100% agree with. However, his choices in the robbery case were going to be informed by what's coming down the pike. And those choices include pleading guilty or going to trial. And as Mr. Yelizarov himself said, he had very little to lose. If he had a full understanding of what was happening in the in the murder case, then different choices could happen in the robbery case.
And Waldman was CJA counsel, is that right?
That's correct.
And the scope of his appointment was only for the robbery, it didn't extend to other potential indictments or crimes?
Well, as things go with a CJA appointment, certainly that was what he was appointed for. But again, this is a situation where everybody agreed that investigating the murder or following up on the prosecutor's information about the murder would have fallen into the robbery appointment, although there would come a time when it would cross over and require
Well, you
additional-
say everybody agreed that that would fall within, but not everybody agreed, certainly, that the investigation would fall within that appointment. What concerns me is that I can't imagine how an attorney would be willing to accept an appointment as CJA counsel if that appointment was essentially unbounded. That it wasn't, when someone accepts an appointment, they accept an appointment for a particular representation, and if it was, for example, if then they were charged with a capital crime and that person, and that attorney that was outside of the scope of their practice, would they then agree to that appointment? I think not, and that's what you're asking us to find.
Again, I agree partially and not fully, Judge Bernard. So I do agree that accepting an appointment for a Hobbs Act robbery does not mean that you have accepted an appointment if they supersede with capital charges. Of course, you'd need to be capital qualified, you need to be learned counsel. But in those situations, usually there's consultation. Here we had Judge Hollander specifically saying to Mr. Waldman, if you had gone to Judge Motz and said, whoa, this bombshell was just dropped, Judge Motz would have either appointed him on that, if that was within what he wanted, gotten him counsel. Counsel are appointed for targets regularly. If it was clear that
Under the Criminal Justice Act there?
they are. I myself have received target
Well, but not
appointments.
because the Sixth Amendment requires that, right? Because there's no Sixth Amendment right to counsel until you're charged.
Correct.
Okay, fair enough.
I mean, personal experience.
No, I
I've had-
accept that. Yeah, sure.
Yeah.
Okay.
But your point is that this is like a real estate lawyer that goes and tells somebody they have clear title to a land and doesn't tell them there's a hog rendering plant right next door. Is that right? And you have an obligation to your client to tell them what their risks are.
Absolutely.
And that's what you're saying didn't happen here. Is that right?
Correct, because his choices about buying that land could not be fully informed. He wasn't able to actually assess his risks, benefits, what he really wanted, without knowing what was on the other side of that fence. And what was on the other, he wasn't buying what was on the other side of the fence. That is a separate issue. But could he make his choice about the first purchase without knowing all the information? And when the lawyer
So can I
knows-
ask you, this just seems like a weird case, right? In the sense of the lawyer's representing him on one set of charges. He potentially gets information about another set of charges. And the question is whether the lawyer is, I guess the first question under Strickland is whether the lawyer rendered deficient performance by not investigating the other possible charges. What is your closest case that says that's deficient performance under Strickland? I didn't see any case in your brief that struck me as terribly analogous to this one.
Well, I think you're right that this is a weird case and not, doesn't show up a lot.
Sure.
Most of the plea, 2255s are kind of a different context. I think that the D.C. Circuit's Aguiar case is really close, where there was clear information that superseding indictment charging successive 924Cs was coming down the pike. I think that's pretty
Okay,
close. I also think it's worth pointing out that when we've got a guilty plea 2255 and we are looking at how that deficient performance impacted the defendant's choices, it's going to trial on the charge that they pled guilty to doesn't necessarily have to be the choice that the lawyer would make or that the appellate court reviewing it would think would be a good idea. It simply has to be a rational choice.
So can I, so you're pivoting to Strickland prejudice, so I have that same question. So your brief says, like, things might have been different, or he might have found some stuff, but you agree for Strickland prejudice. So what in fact happened is that he took this plea deal, right?
Right.
And Strickland prejudice says, I have to have a reasonable probability that the outcome would have been different. And it strikes me that the two other possible outcomes here are, he goes to trial, so he rejects the plea and goes to trial. The other possibility, which is adverted to in your brief, is maybe they make a global plea agreement. But it has to be one of those two things, right? It can't just, I guess you agree, there's no such thing as prejudice in the ether. Like, the lawyer would have found some stuff, but he still would have pleaded guilty. That's not Strickland prejudice, right?
Not in this case.
Not in any case.
Well, in some cases, the 2255 counsel might have found amazing mitigation evidence and.
Right, but then that creates the possibility that the underlying proceeding would have reached, like, so capital
Right.
stuff, where you would have found some amazing mitigation stuff, and if you found that amazing mitigation stuff, the jury might not have given your client the death penalty.
Right.
But you agree that there's no such thing as Strickland prejudice in the ether, right?
Correct.
So what is the best evidence that but for this, the outcome of the proceedings might have been different? Either he would have gone to trial, or notwithstanding the fact that the government expressly rejected a global plea agreement, they would have notwithstanding had a global plea agreement.
I think the best evidence is, there's two pieces. The first is some of the contemporaneous evidence was the sentencing proceedings on the robbery, where defense counsel and Mr. Yelizarov themselves were both clearly contemplating that he would be released from prison when he was in his early 50s. So that evinced a lack of understanding that something else was to come. So that's one piece of evidence that relates specifically to the choices that were made. Another is Mr. Yelizarov himself saying, what did I have to lose? And what did he have to lose? If he knew he was going to ultimately be serving 50 years or, who knows more, because.
But he might have thought he was going to get acquitted of the murder, which is what he told his lawyer.
Sure, he might have thought that, but you've got to be able to go to trial to get acquitted. You certainly will be convicted if you plead
No, but he
guilty.
could have concluded the rational outcome was plead guilty to the robbery because they've got me dead to rights on the robbery, so get the lowest sentence you can on the robbery. I'll go to even if they do charge me on the murder, I'll go to trial and I'll get acquitted, and then I will get released in my early 50s.
Well, Your Honor, I really think that outcome that you just described is guessing. It's looking at, what could happen without pointing to what the evidence in the record really was. That is a pie-in-the-sky best case.
Sure.
But Mr. Yelizarov had the more realistic, what do I have to lose if I'm going to, and certainly plenty of clients say 30 years life, who cares? A lot of lawyers need to talk to their clients about why that's not necessarily true. But if he knew he was looking at 50 years, why not go to trial? Apparently, many of the witnesses would have been the same. It's clear that it was very important to Mr. Yelizarov to challenge the credibility of these witnesses. And sometimes you go to trial, not because you think you're going to win, but because you've got a point to make. And that, that might have been what his purpose was.
What was the point?
To
That he would be-
challenge the credibility of the cooperating witnesses.
So
Can I ask you a question?
Of course.
About a slightly different topic. Tell me about how you get around the waiver of appeal on the sentencing issue.
Two ways. The first is that the resentencing occurred because Mr. Yelizarov was actually innocent of one of the offenses. So that takes it out of most of this court's appeal waiver cases to begin with. Where there is a change in sentencing law, that is a very different situation from where there is a change in the substantive law about whether someone is guilty or innocent.
Well, then how do you get around the fact that he signed this plea agreement that said I get 30 regardless of what happens to the 924 charge.
Well, that you get around with the fact that he signed this plea agreement based on ineffective assistance of
So
counsel.
you have to go back to the ineffective assistance in order.
So let's bracket that. Because let's assume I agree with you that if he had ineffective assistance of counsel at the plea agreement, the waiver's invalid. But bracket ineffective assistance of counsel. How do you get around it if there wasn't ineffective assistance of counsel?
I think that, well, first of all, there's a couple reasons. The actual innocence of 924C is a
But
huge factor.
he doesn't currently have a sentence for the charge for which he's actually innocent. The case you cite is a case that says, in a situation where a charge you've been sentenced for is a charge of which you are now actually innocent, we don't enforce the appeal waiver. But as he is before us today, he has not been sentenced for any charge for which he's actually innocent, right? He's not been sentenced on a 924C count.
Correct.
So what case says you can get around the appeal waiver in that situation?
The appeal waiver was in a document that he signed that included the 924C.
And that as Judge Gibney said, that expressly referenced the possibility of exactly what happened here.
It did, but these contracts have to be construed against the drafter or against the government.
Which is why the government put in a clause like this that says, if this happens, the waiver is still valid, and your client signed a contract that said, if this happens, the waiver is still valid.
Well, we've got a situation where these, I know you said to bracket the two, but they're so tightly connected that to separate these out, he wouldn't have been resentenced without a 2255 being granted at all. Granted, the 924C 2255's in a slightly different position than the one that I'm otherwise mainly talking to you about. But something happened in that plea on several levels that was kind of problematic. And so as a result, the document, that plea waiver that contemplates the 924C, it's not worthy of the same consideration that this court would normally give plea waivers.
So even if we agree with you that there's not been a waiver, how do we get around this court's opinion in Withers? I understand your argument to be that the sentence was unreasonable because it was different from the sentence of the co-defendants or the co-conspirators, but Withers says we don't consider that.
So that's only one of the aspects of the unwarranted disparity. There's also an unwarranted disparity on other individuals who are resentenced after having a 924C vacated. And brandishing 924C, everyone knows, is 7 years. And so to not account for that in the explanation, and ultimately—
Is there a case in our circuit that says that a sentence is categorically unreasonable if the defendant gets the same sentence after a charge is dismissed? I couldn't find a case that said that.
There's not. The same sentence could be imposed.
So how is the sentence unreasonable?
It's procedurally unreasonable because of the failure to explain that particular 3553.
Well, for crying out loud, this man went out and robbed a bunch of guns from somebody that he clubbed over the head, then took a man, kidnapped him, locked him in his car, went and robbed a store, and then left him to die in his trunk. How much more explanation do you want for 30 years, you know?
Well, Your Honor,
I realize that the Fourth Circuit second guesses opinions a lot, but this is one that just cries out for a long sentence.
Your Honor, I hear you, and I am not saying that, a 5-year sentence is appropriate by any means. I think that what you were alluding to is a question of the substantive reasonableness as opposed to the procedural reasonableness.
Well, you're saying that she didn't explain it enough. I say that the facts explain it plenty clearly, and she said it was a horrible crime, and he got 30 years for it.
And that, yeah, I do hear you. That is a circumstances of the offense aspect of 3553 and is different
So
from—
you're saying there's a checklist of things you have to say?
To a certain extent,
Well,
yes.
as a district judge, I could say that that's a problem.
I understand, Your Honor. I see that my time is up.
Thank you. You'll have some time on rebuttal. Mr. Budlow.
morning. May it please the court, Your Honors, my name is Paul Budlow, and I'm here on behalf of the government. The district court properly found that the defendant had effective assistance of representation, and counsel gave him sound advice when counsel came to him and told him that he was the target of a wholly unrelated, years-old, cold case homicide. And he said, I already know about that. I'm not interested in a global plea, even though the government never offered one. I'm not worried about it, and they're never going to be able to prove it. That's what he said. And
Mr.
therefore,
Budlow, can I just ask you something that's been driving me crazy ever since I read the briefs in this case? Why did the government drop this, what I'll delicately call neutron bomb on defense counsel 10 days before the plea hearing on the robbery charge? It's hard to escape the inference that the reason you tell his robbery lawyer this is that you think it has something to do with the robbery lawyer's job. I don't know, otherwise I don't literally know why you tell the robbery lawyer this.
sure, and Your Honor, I was trial counsel below, so I'm going to try to stick with what is in the record.
Please do.
In the joint appendix. I would state that the government represented below and does here today. The government was under no obligation to.
So why'd you do it, man?
Well, hindsight, right? So at the time that the plea negotiations were going on, and this is in the trial court's opinion, the investigation was covert, it was sensitive, it was an old homicide. It was not something that the government wanted the defendant or anyone else to know about. At the time the defendant signed his guilty plea, things had changed enough to where the government was comfortable revealing that information to the defense, and then informed the defense essentially to avoid later litigation that the defendant would say, I didn't know about this.
I would have never pleaded guilty had you not told me this.
Which not necessarily would have been valid, and maybe hindsight, the government could have not done that, and we'd still be fighting this battle either way. But that was the calculation, was get it out there on the table. And
Well, what did you expect the lawyer to do?
I expected the lawyer to do exactly what he did in this case, which was particularly effective, which was go to his client and tell him about it, and then we would see what would happen. It was clearly outside the scope of the attorney's representation of the defendant.
So was he correct that the attorney-client privilege would not have covered his notes?
I don't know that he was correct about that, Your Honor. I mean, certainly in the 2255 context, there are situations like this case where down the road, the attorney-client privilege is waived. I don't know that Mr. Waldman was correct.
Well, I don't think he was saying that attorney-client privilege would be waived. I think he felt it wouldn't cover it at all, and that's why he was concerned and didn't take notes. He didn't further investigate. He had a conversation, but he didn't go any further, and that's,
Yet,
was that proper?
I'm sorry, to be clear, Your Honor, two different questions in there. Was he correct that there was a attorney-client privilege? And I don't know the answer, but that, he didn't indicate that the reason he did nothing further had anything to do with the attorney-client privilege. His testimony on that was he didn't take more notes because he was concerned with that. And obviously, the notes that he discussed at the hearing were quite revealing. The defendant indicated that he already knew about the investigation. He provided names of two people. It was a bit vague, but it seemed to be that he knew that they knew about the investigation.
Well, but didn't he say that I didn't go into this any further because I was concerned, I didn't take any notes about it because I was concerned that my conversation at that time with the client was not protected by the privilege?
Yes.
And that's hogwash, isn't it? Well, every time you talk to your client and the client asks you for legal advice, that's protected, isn't it?
I would absolutely think so, Your Honor.
Yeah.
But he did say that's why he didn't take notes. He did not say that that had anything to do with his reasons for not investigating. His reasons for not investigating were essentially two or threefold. One, the government said, you're not getting any more information than this very limited information, which was there's this serious case, it's a homicide, the government thinks the case is strong, your client's likely to be indicted, and it has nothing to do with this case. We're not interested in a global plea. Then he went to his client. His client said, I know about it, I'm not interested in it. And then he said the government essentially stonewalled him. So his testimony as to why he did not investigate, which there's no obligation in professional norms, in any case law, anywhere that was presented below, there was no expert testimony, there was no evidence below at all that there's a professional norm or obligation to investigate wholly unrelated case that had no consequence in this case.
Although Mr. Yelizarov specifically said that he would be out in his 50s, and that was important to him, and that therefore he would be in prison for no longer than 30 or around 30 years. He was in his 20s, and accepted the plea on that basis. And so would he then, I mean, is there a question about whether he would have accepted the plea had he known that these charges were serious?
Well, I believe that the testimony Your Honor is referring to is at the ineffective assistance of counsel stage when the defendant testified that he thought he would be bound in his 50s. But I think the record is crystal clear, regardless, that the defendant had a complete knowledge of this. He alleged below in all of his pro se filings through his attorney, and again here on appeal, really the gravamen of this case is that he was told that if he pled guilty in this case, that would foreclose any further prosecution. But the trial court held a hearing, 2 days, 3 witnesses, and made specific findings, completely finding that that was not true. The trial court found at Joint Appendix 504 through 510 that Mr. Waldman did tell the defendant about the investigation and all of the things that we've heard today about what the defendant said. I'm not interested, they can't prove it, I'm not interested in a global plea. But critically, what the trial court found was that Robert Waldman told the defendant about the consequences of the guilty plea in this case and that they did not preclude a future murder prosecution. And not only that, the court found that it happened twice. So at the initial time when they learned about the homicide investigation, then the defendant withdrew from that guilty plea, directed Waldman to get him additional counsel for a second opinion, which he got. Then the defendant came back to Waldman, initiated plea negotiations again, and then Waldman, when he brought him the final plea agreement, advised him for a second time, as found by the trial court, that he said this would be a good time to remind him that a guilty plea in this case would not preclude a future murder prosecution. And additionally, on the same point of his notice and how that issue is foreclosed, the trial court found that the plain text of the plea agreement was inconsistent with the defendant's claim that he could not be prosecuted. So both the plea agreement itself and the Rule 11 colloquy made it clear that the defendant was fully aware that the plea agreement related just to this case. This court really should decline to impose an obligation on defense attorneys that it has never imposed, that exists in no standards, no professional norms, namely that a defense attorney has an obligation to investigate and even attempt to resolve an unrelated criminal investigation that's not part of the case. And further, that this obligation somehow exists in a situation like this where the client says, I already know about the unrelated conduct, I'm not interested in it, I don't want to plead to it, but I do want to plead to this case.
How would you advise us to distinguish Aguilar, the DC Circuit case I may have?
Your Honor, Aguilar involved an attorney advising his client in rejecting a plea agreement in the face of additional 924Cs that would clearly stack. That had consequences inside that case, and it involved conduct inside that case. And this speaks to a point that Your Honor questioned defense petitioner's counsel about earlier. That is in opposite here because unlike that case, the conduct that's being complained of here is outside of the case. So the defense is claiming that Mr. Waldman should have done something having nothing to do with this robbery.
And when we say outside the case, I'm just trying to make sure I understand what we mean by outside the case. Do we mean it's different in time? What if the indictment in this case, I mean, this is going to be a weird set of facts, but what if the indictment in this case did not charge a murder but alluded to the circumstances that might have supported a murder charge? What do you think the answer would be then? Because as I recall, one of the things I remember the DC Circuit saying in Aguilar is like, you just have to look at the initial indictment. The initial indictment makes clear you could be charged with other 924C offenses.
Right, and in this case, what Mr. Waldman was presented with is that he was engaged, his scope of representation was for a conspiracy that spanned between 2012 and 2013, and it involved a conspiracy to rob guns and jewelry stores and to kidnap people.
How do I know that's the scope? Is that because of his representation agreement? Is that because of the indictment that he was defending? When you say,
yes,
you just represented what the scope of his representation is, how do I know what the scope of his representation was?
At Joint Appendix 18 and 19 is the first 2 pages of the indictment. Mr. Waldman was appointed after the indictment. He was appointed to represent the defendant in that case. And in that case involved conspirators and this 6-month conspiracy. On the other hand, the murder case that he was informed about, that information he knew and he could make this decision is somehow related, was a homicide. It was 2009, and it was in a situation where the defendant acted alone. And I believe Mr. Waldman testified at the 2255 hearing about whether or not there were other co-conspirators, because he smartly asked that question to see if there was not just a global plea, but potential cooperation, and he was informed that the defendant acted alone. So here, we have a case that's separated by time, many years. It's separated by conduct. One is robbery, and kidnapping, the other one is a murder that was for revenge. And I'd remind the
So
court that
did you prosecute the murder case?
I did.
Did any of his co-conspirators testify in that?
No, there was, he pled guilty on the first day of
Okay.
trial.
Were any of them witnesses, to be witnesses in that?
I'm reluctant to answer the court's question with respect to cooperators, Your Honor. I could certainly provide that information after the hearing under seal.
Well, you probably just did.
Yeah, maybe.
Didn't Mr. Waldman himself testify that he could have done an investigation? So if he could have done an investigation, wouldn't he be obliged to do so?
No, I mean, Your Honor, respectfully, there's lots of things counsel could do that fall in the wide range of possible conduct from a defense attorney when representing a defendant. So,
But here he was representing the defendant in a plea discussion where his client told him that one of the reasons he was accepting the plea was because he wanted to be out in his 50s. So they were having a conversation about the plea agreement. Counsel, Mr. Waldman, knew that there was this other potential indictment that would cause his client to be in prison far longer than the agreement called for, and yet he failed to investigate when he knew he could.
well, it's completely unrelated. And again, the government would ask the court not to expand the scope of representation and impose an obligation on every defense attorney who has representation for the client in one case to represent other cases. But the other thing I'd note, Your Honor, is that what Mr. Waldman was faced with did not give rise to an ability to get any or much information at all, particularly when the government had stonewalled him. It was an old case that was closed. There was no discovery obligation. And his client looked at him and said, I know about it. I know more than you do, and I'm not interested. And so under those circumstances, Mr. Waldman had no obligation to pursue this completely unrelated investigation. His obligation, which I think he did, was two things. One, he told his client exactly what the consequences would be of the plea and of the future murder prosecution. And he negotiated the plea agreement in this case that his client asked him to do. His client said, get me a better plea. And at the time, he had signed a plea where the government could ask for 40 years. He came back with a second plea after getting a second opinion with a plea agreement that was a C plea to 30 years. But more importantly, was also agreed that it would run, the government agreed not to oppose, that it would run concurrent to an 11-year sentence the defendant was currently serving. The guidelines were over 30 years. So this was a plea agreement that was
30 plus, right?
They were 30 plus at the second sentencing, but at the original sentencing, they were higher. So this original sentence that Mr. Waldman negotiated was far below the guidelines. Then when it came to Judge Hollander at the resentencing, the guidelines were recalculated and they were 30 to life. Again, the government would argue that this also was a below guideline sentence because the
And it was a
guideline.
Part C plea.
It was a
So
C under
court
Rule
couldn't
C1C.
change it. The court could not have changed it, could not have gone. the
Well,
court could have
that was-
rejected the plea.
That was
but
the government's argument below, but in looking at the court's rationale in the sentencing hearing in this case, Judge Hollander did not accept the argument that Judge Hollander was bound by the C plea agreement. And like she would do in a C plea agreement, she engaged in a full colloquy and hearing and provided reasons and reached the 30-year sentence on her own for other reasons, some consistent with the government's memo, but other reasons other than the fact that the C plea called for it. She did consider, however, the fact that the defendant had agreed to it, and that was one of the factors that Judge Hollander did consider. Your Honor, turning to the sentencing in this case, the district court properly sentenced the defendant to 30 years imprisonment, which was precisely the sentence that he bargained for. And as Your Honor, Judge Gibney noted earlier, the government's view is this court should dismiss this sentencing appeal because the defendant signed a Rule 11C1C plea agreement that the defendant was sentenced consistent with, and he agreed in that plea agreement to waive his right to appeal the sentence on whatever grounds. And so this court should dismiss that appeal based on the appeal waiver. But even if the court were to address the merits of the defendant's appeal on sentencing, the court should affirm because the sentence was both reasonable, both procedurally and substantively reasonable. I would like to address the waiver a bit more, Your Honor. There are a couple of cases cited by the defense, Adams and McKinney, that were both situations where this court declined to enforce an appeal waiver relating to a 924C charge. As Your Honor, Judge Hayden's referenced, though, both of those cases involved a 2255 and a motion to vacate the sentence. In this case below, the government agreed with the 2255, and the sentence was vacated, and the defendant was resentenced. So the sentence, the 30-year sentence before your honors today, when evaluating the waiver, has nothing to do with the 924C conviction whatsoever.
Because his sentence on 924C is currently 0, right?
It is exactly 0. There's no conviction on 924C. And so Judge Hollander, using the sentencing package doctrine and engaging in a holistic approach, sentenced the defendant to 30 years on counts 1 and count 4, which is precisely what the plea agreement said. And to put that in a bit of context, when this first plea agreement, or when the second plea agreement was enforced, and the defendant pled guilty, the parties were very much aware of the changing landscape in the law of 924C and which statutes were and were not predicates. But the parties reached an agreement that 30 years would be the sentence in this case, squarely looking at that uncertainty and trying to come up with a way that would say, even if 924C is reversed, you're going to come back and get resentenced. It's going to be 30 years. You're going to get the finality you want. The government's going to get the finality they want. And the appeal waiver is going to make it clear that it doesn't matter what happens to the 924C. And so unlike those cases in Adams and McKinney, not only are we in the situation where those were vacating, but there's a notice issue as well. Here, the defendant was completely on notice. He overtly and expressly anticipated that we would be in this exact situation. The defense also alleges that there's a procedural unreasonableness because the trial court didn't address the disparity in sentencing. The trial court did address disparity in sentencing. At Joint Appendix 823 to 824, the court specifically referenced that she had done a lot of research. She mentioned a number of sentences that she had imposed and sentences she had reviewed in the compassionate release context, and she mentioned sentences of other judges. So the trial court was making it clear that as part of the 3553A analysis, the court considered A6 relating to sentencing disparities. What counsel argues for in this case for sentencing disparities is not the sentencing disparities as anticipated under 3553A. As this court held in United States versus Mosley, sentencing disparity does not apply within the case between co-defendants, but instead applies nationwide. And that's essentially what the trial court was doing here. The other point is that there is no sentencing disparity between co-defendants in this case, because as this court mentioned, the conduct that the defendant was the leader of was extremely serious, violent, well-planned conduct. He's the only leader. The defendant is the only person of this group with a criminal history that includes the execution-style homicide of Wayne Reuter. So there is no defendant similar, and 3553A6 says that the court should avoid unwarranted sentencing disparities among defendants with similar records, there's none here, and who have been found guilty of similar conduct, there's none here. Now, the defense has another creative argument that disparity wasn't covered because the court didn't properly address the reasons for imposing the same sentence for the vacated 924C conviction. Again, the court did, but I would start by saying that that is not what 3553A6 covers. It doesn't cover defendants who are in similar procedural posture. It discusses defendants with similar records and similar conduct. And as the district court noted below, upon remand, the court can use the sentencing package doctrine to sentence the defendant with the remaining counts consistent with 3553A. And the court is also to consider the defendant as he is at the time of sentencing, which is exactly what the district court did here. The district court referenced the sentencing package doctrine. The court recognized that it was engaging in a holistic approach and that the final sentence was part of a larger plan. And the court said that the court was not required to reduce the sentence by 84 months, but did consider the defendant's request. So there was no procedural error relating to the defendant receiving the same sentence upon conviction. Your Honor, I see my time is up. Unless the court has further questions for me, I'm prepared to sit down.
Thank you very much.
Thank you.
Skelton, you have some rebuttal time? Before you get into that, I just have one question I want to ask you, which is this: I understand I'm going to be out at 50 stuff that we've been talking about. Am I correct that that was his testimony at the 2255 hearing, not when he was sentenced?
No, that was when he was sentenced to begin with.
What is the JA cite for that proposition?
1 moment, Your Honor.
Okay. So just to be clear, my understanding is that he testified to that at the 2255 evidentiary hearing, but that he did not say that at the Rule 11 colloquy, and that he did not say that at the time of his original sentencing.
I'm sorry, my transcript notes were before the JA. The sentencing, April 13th, 2016, page 13 of that sentencing, and I'm not quite sure what the JA is.
That's fine.
That is where, actually, it's Mr. Waldman who says that he will be out in his 50s, and the sentencing memo that he filed before the sentencing also says the same thing.
Okay, thank you very much. Go ahead.
Your Honors, something I kind of want to make clear with respect to the portion of the plea agreement that talks about whether, what is precluded for prosecuting later. We are not standing here today saying that the government breached its plea agreement in the robbery case by prosecuting the murder case. We are not saying that that plea agreement precluded that prosecution. So which kind of goes to the prejudice. We're not saying that the murder case was off the table. That's really not where the prejudice is here. It is, Judge Haytens, I think what we were talking about, where we really are focusing on what is the prejudice in the robbery. And that prejudice is, would he have gone to trial or not whether he would be prosecuted later or not. I hope I'm not confusing things by bringing that up, but the validity and the counsel's understanding of that paragraph, and I think counsel's understanding of that paragraph was a little confused, which is troublesome. But that goes to what his advice was in the robbery. I understand what Mr. Budlow was saying about not asking this court to impose additional obligations on defense counsel to investigate things that are just out in left field. But the four corners of the indictment cannot possibly be the limitations of what defense counsel's obligations are, because that is always the smallest bit. What if the case went to trial and there was 404B evidence lurking out there and counsel was totally blindsided? That would be bad. And that's obviously not going to be in the indictment. The indictment is a starting point, but if that is it, then there's a real problem. Counsel has to go beyond those minimal.
And what would the limiting principle be then?
Well, the limiting principle,
I just struggle with how this rule would be written.
I understand, and I'm afraid my answer might dance around it, but at least the fact that the prosecutor told the defense counsel in this case shows that whatever the limiting principle is here, or broader here, the murder falls within the limiting.
But wait, that's not right, because imagine that keep everything about the same except the original charge is securities fraud. Everything is the same except the original charge is securities fraud. And so then the government says, by the way, before you do this plea to the securities agreement, just FYI, your client's about to get indicted for a murder. You say that the securities fraud lawyer has to investigate the murder?
Has to probe, doesn't have to, solve the case, but has to.
Thank goodness. I don't think I'd want a typical securities defense lawyer investigating a murder.
No, and perhaps at that point, what the obligation really is to go to the judge, maybe have a under seal, status conference and say, I think we need a minute. I think he needs another lawyer. I don't think I can advise on what's happening here until we get a little bit more information. And so it's not necessarily that the securities lawyer has to do everything for the murder, but has to take enough steps so that the defendant knows what's up.
Okay. Thank you, Ms. Skelton.
Thank you.
I noticed that you are court appointed. Is that correct?
It's correct.
Well, it seems particularly appropriate during Public Defense Week to thank you and recognize you for your work in this case. We very much appreciate it. We could not do our jobs without the help of people like you. So thank you very much.
Your Honor.
We will come down and greet counsel and go directly to our second case. All right. While folks are moving around and getting settled, I will just note that our next case is number 23-1733, J.H. versus Harford Mutual Insurance Group. I see we have divided argument for the appellants, so please do not hesitate to let me know if I get this wrong, but I believe the first person we're going to hear from is Mr. Bulfer. That's correct. Okay. Take a minute to get settled and come up to the lectern whenever you're ready.
Your Honor, before I get started, I note that the timer says 10 minutes, and I was told I was to keep account of my own separation of time.
So what I have down on the sheet, just so we're all on the same page, is that my understanding is you have a total of 12 minutes, 10 minutes for your initial argument, then your colleague has 8 minutes, then you have
Correct.
2 for rebuttal. Is that what you intended
Yes.
to do?
Yes.
So that does not include your rebuttal time. That is your initial 10 minutes.
But it does include all of my time.
Your initial 10 minutes, yes.
May it please the court. My name is William Bulfer, and along with my law partner, Dan Strong, I represent Harford Mutual Insurance Company. Magistrate Ald's decision to ignore the face of the underlying complaint and look beyond the plain and unambiguous language of the exclusion at issue improperly bound Harford Mutual Insurance Company to a risk that it never contracted to guard against. The bodily injury in this case that is identified in the underlying complaint is inextricably intertwined with the ownership, operation, and use of the motor vehicle in question. What Harford Mutual Insurance Company is asking.
Negligent entrustment is a different tort from negligent operation of a car, right?
It is a different tort, yes, Your Honor. However, the tort of negligent entrustment requires under North Carolina law as the Court of Appeals in 1998 discussed in Coble versus Knight, requires ownership as a necessary element of that tort.
So why didn't they say negligent entrustment when they were doing the exclusion?
The short answer, Your Honor, is they didn't have to, because
So why do they say it in the aircraft exclusion?
why did they say it in the aircraft
Yeah.
exclusion? There are a number of reasons that they would say it in a subsequent exclusion, none of which, as the Supreme Court in the Wachovia Bank and Trust versus Westchester Fire Insurance Company, Supreme Court decision from North Carolina, are relevant to this court's decision on whether the exclusion itself applies.
So let me put it this way. Assuming that the automobile liability exclusion, by its terms, is enough to preclude a negligent entrustment claim by itself, why does that not mean that the words, let's see, that involving entrustment of others in the aircraft exclusion, why aren't those words completely superfluous? Because you could strike those words and the aircraft provision would mean exactly the same thing.
A number of reasons, Your Honor. First of all, as the Wachovia matter discussed, when to insert a provision which will eliminate the remotest possibility of litigation upon a given theory is not a recognition of the reasonableness of that theory in procuring coverage.
Sure, well,
So-
but that's an argument for leaving the words entrustment to others out of this agreement entirely. What I don't understand is why they include it in some provisions and not others. I don't know what the theory of why you would do that is.
Certainly. So the Seventh Circuit in Standard Mutual versus Bailey actually had the same curiosity.
Okay.
They said, we find it curious that in view of the plethora of litigation on this issue, the insurance industry hasn't simply added the word entrustment.
No,
They-
but that's an argument about a contract that doesn't have entrustment at all. What I still don't think you've answered is, in what universe does it make sense to include entrustment in some provisions, but not include it in others, if the proper interpretation of the agreement is that you never need to include entrustment at all? That doesn't make any sense to me.
Because they're separate exclusions. Because they're
But it's one
mentioned-
contract!
Well, do you think people are more likely to lend their airplane to somebody than their car?
So, in complete candor, I haven't looked at all of the ins and outs of airline risk and underwriting sort of rules that would go into the development of that particular exclusion. Also, the record has nothing about underwriting in it. What it does have is a clear indication of what this exclusion says.
Well, if we
And-
read this exclusion in isolation, that would be true, but North Carolina law says you read the contract in its entirety. You don't read one exclusion, and at a minimum, I think it creates ambiguity, and under North Carolina law, we're told that we need to construe all ambiguities against the drafter, against the insured, in favor of the insured, against the insurer. So even if we were to agree with you that this one provision is clear, the entirety of the contract does create ambiguity.
So respectfully, Your Honor, that is the North Carolina Farm Bureau versus Martin case, the North Carolina Supreme Court decision from 2020 says the opposite of that. What it says is you don't get to the other portions of the contract in that harmonious discussion unless the exclusion itself is ambiguous. In this situation, the exclusion is unambiguous.
Don't you have an obligation to give every term of the policy some meaning?
Not when you're looking at other exclusions that relate to a wholly unrelated risk. The risk here is a motor vehicle risk. The accident here is a motor vehicle accident. And one need look only at the actual allegations of the second amended complaint, and specifically the negligent entrustment allegations in that complaint. So let's discuss what the plaintiffs in the underlying complaint alleged. At Joint Appendix 41, paragraph 91, the underlying plaintiffs allege ownership. They allege that the vehicle was being operated. And they allege that that ownership and that operation resulted in bodily injury to the plaintiff. Those are the exact same words in this exclusion that bar coverage for these types of claims.
Can I just ask, are
Please.
you and your colleague dividing is he doing the interest issues? 'Cause I
Yes,
have
sir.
some- Okay,
Yes, Your
thank you very much. I just wanted to make sure.
Oh, okay.
If
I didn't know if there was
I want to
actual
make sure if I
questions.
had some questions on the interest, who I asked the questions about the interest.
That
Go.
would be Mr.
Okay,
Strong, Your
great.
Honor.
Thank you.
I could attempt to answer them, but they probably wouldn't be as good.
Carry on.
So when we look at that exclusion, we look at the plain reading of the complaint itself, they overlay completely. There is no ambiguity. What Judge Auld did was he looked beyond that exclusion to create an ambiguity by reaching into a completely unrelated exclusion. You don't look at asbestos exclusions to decide what an auto exclusion does. You don't look at watercraft exclusions to see what an auto exclusion does. You look at the auto
See, I
exclusion.
was with you on the first one of those. Like, that was a good line. You don't look at asbestos to decide what the auto, and my answer is, because those seem like they have nothing to do with each other. But I don't know, like, I might look at a provision about vehicles to decide what a provision about vehicles means. That doesn't strike me as at all strange.
So even if Your Honor finds that those things are not strange, that you do look at the aircraft exclusion and the auto exclusion, what you need to look at is the particular allegations of this complaint. And you need to look at how those allegations relate to the exclusion that we are discussing. The exclusion we're discussing, which is contained on page 186 of the Joint Appendix, says, "It is agreed that this policy shall not apply for bodily injury." We all agree that this is a bodily injury case. The face of the plaintiff's complaint has a picture of a motor vehicle accident that shows how that bodily injury took place. Then it says, "It shall not apply to bodily injury, personal injury, or property damage arising out of the ownership." Ownership is a required element of pleading for negligent entrustment. Maintenance, operation. We need look only again at that complaint to see that the vehicles in question were being operated at the time of loss.
Under North Carolina law, who bears the burden of proof on whether or not an exclusion applies?
Once the plaintiffs have fallen within coverage, or once the insured falls within coverage, Your Honor, the insurer carries the burden or holds the burden of proving that an exclusion applies. The problem with the
So your
balance-
client bears the burden of proving that this exclusion
We do, Your Honor.
applies.
However, if you look at Judge Auld's decision, the very act that Judge Auld found gave rise to coverage in the first place. That deals with the underlying plaintiff's burden, or rather the insured's burden in this case, was the occurrence and bodily injury that resulted from that occurrence. What is that occurrence? It is the use of a motor vehicle giving rise to bodily injury. In the absence of that use and operation of a motor vehicle, there is no bodily injury, and the underlying insured doesn't even fall within coverage. So you can't have both. You can either have the accident in question that gives rise to the question of coverage, but then you got to look at what that incident was. What was that occurrence? And is it particularly excluded by the exclusion in
So
question?
can I ask you a question about your claim, as I understand it, that in deciding whether this provision is ambiguous, the only thing we can look at is this provision? doesn't that at least have to be wrong in the following sense? At minimum, don't I have to look at the rest of the contract to see if there is another provision that claws back some of what this provision does? Because that happens all the time, right?
Yeah,
So it can't literally be that in deciding whether this provision is covered, is triggered, I can literally not read anything in the contract other than this provision, because at minimum, I have to check if there are other provisions that claw back part of that, right?
That's correct, Your Honor. You have to look at related provisions. What you don't have to do, again, back to the asbestos exclusion issue, you don't have to look at unrelated provisions. So if this section, for example, if this was an auto policy, and the auto policy, then sought to exclude auto risk, you would look at those things. Because
And then
they
if there
could
was
be
an
in
exception to
conflict.
the exception, I'd have to look at that
That's
exception to the
right.
exception.
But what you don't do is you don't look at completely unrelated exclusions and inject those into a clearly worded, unambiguous exclusion that the vast majority of circuits have found is unambiguous, even in cases where negligent entrustment is the cause of action.
Do you know of a case that has confronted this situation, where there's an auto policy, an auto provision that doesn't say negligent entrustment, and then there's provisions about other types of conveyances that do say negligent entrustment? Do you know of any case saying that's not ambiguous?
Not in the negligent entrustment context, although the cases
A case
that
like
do-
this one, say.
Yeah, nothing that's completely on all fours. What I would say, Your Honor, is, and I see my time is up, if I
Go
can
ahead.
answer your question.
Absolutely.
What I would say is that the Wachovia case is the closest to be on all fours, because what it does is it discusses what happens when there are different portions of a policy and how it is improper to look to those to either create an ambiguity or change what the clear terms of this policy would be.
No.
Thank you very much. We will hear from Mr. Strong.
Good morning, Your Honors, and may it please the Court. My name is Dan Strong, and I'm going to address the imposition of judgment interest on the settlement that was reached between the parties. Simply put, no judgment interest should be applied in this matter, as no judgment for money damages was ever entered against a Harford insurer.
And where did you ever make that argument before the district court?
Yes, Your Honor, so Magistrate Auld mentioned that in Harford raised that no judgment was ever entered until it argued it in its reply brief.
Right.
But we actually raised that argument in the opening brief which is at Joint Appendix 617. It's Joint Appendix 607. Harford argued that, and I quote, "The litigation agreement was a negotiated settlement agreement between the parties in the underlying litigation and the defendants." And then later down in that same page, "Therefore, the issue before the court in this action was one for declaratory judgment and enforcement of the litigation agreement, not for judgment in the underlying litigation, which was not filed per the terms of the litigation agreement itself." And
Okay,
I-
so that is at best an argument that when the district judge said you had waived it by not raising it until your reply brief, that the district court was wrong to conclude that. Let's posit for the sake of argument that you're right about that. Where in your opening brief do you say the district court was wrong in concluding that we waived this argument?
Correct, and Your Honor, we argued that in, and I'll say,
I mean, I know you argued the judgment issue, but where do you argue the district court was wrong in concluding that we've waived that argument?
correct. So our argument is, on appeal, is that Magistrate Auld was incorrect in issuing judgment interest on.
Right, but that's an argument that
judgment.
the magistrate judge was wrong on the merits, but the magistrate judge didn't reach the merits. The magistrate judge said, I'm not considering that argument because I've concluded you waived it. Now, maybe the magistrate judge was wrong about that, but where in your opening brief do you argue to us that that waiver holding was wrong?
Your Honor, I think in our opening brief in pages 37 through 39 is where we address the imposition of.
You address the imposition, so are you telling me that you don't in fact argue that the waiver holding was wrong? I don't recall seeing that in your opening brief.
Your Honor, I don't have the opening brief in front of me, but the citation I've provided you is.
And if I'm wrong, I
37
apologize.
Through
Okay.
39
Thanks.
of our opening brief. Moving forward with the imposition of judgment interest, there's no ambiguity in the litigation agreement itself. The litigation agreement was a valid settlement agreement entered between the parties. The parties had a meeting of the minds as to the imposition of interest, and this is clear when you consider the potential outcomes that the litigation agreement would have provided. The first being that coverage is found. In Section 5 of the litigation agreement, the parties outlined that in no event shall Harford be required to pay more than $2 million under the Big Boss excess policy. In that same section, if coverage
Well,
is not.
I have both of them in front of me, and in the litigation agreement, it says that it in no way relieves Harford insurers of any obligation to pay money under the policies. And then in the policy, it says, the Big Boss excess policy explicitly provides for payment of prejudgment and post-judgment interest beyond the terms of this policy. So how does that not preclude your argument?
Well, so, Your Honor, in the Lunsford v. Mills case, the insurer's obligation to pay interest on a judgment is governed by the language of the policy. And in looking at the language of the policy on Joint Appendix 148, under the defense and supplementary payments provision, it says, when we, Harford, have the duty to defend, we will indemnify the insured for, and number 5 is prejudgment interest awarded against the insured on that part of any judgment covered under this policy. And there was never an award entered against a Hartford insured. The consent judgment was only to be in place if the upfront monies that are considered in the litigation agreement were not paid, and they were, and so that consent judgment goes away. It's never filed, it's never entered, it does not exist against a Hartford insured. And to be clear, kind of strengthening that point is that a voluntary dismissal was filed in the underlying action. And so that is what gets you to the Hartford shall not be relieved of an obligation to pay under the policy, is that to the parties, myself in drafting the litigation agreement, the intent is to a section, I believe, above where you're quoting, it states that withholding or maintaining ripeness of the issues for the appeal, ripeness of the coverage issue for the appeal. And so the intent is to, where there's a voluntary dismissal of the underlying action, that the parties will be able to continue to litigate the coverage issue and have entered the litigation agreement to mitigate the risk to all parties involved, but to litigate the coverage issue on appeal or at the district court to make a determination as to whether coverage existed at all or not. And as going back to the potential outcomes of the litigation agreement, if no coverage was found, it's clear the last sentence of Section 5 of the litigation agreement states that there will be no recovery for the appellees on the upfront monies that were paid. So
And where exactly did you make that argument before the district court? The upfront monies argument. I know you, so the argument I know you made on interest before the district court is that we're capped at $2 million. We can't have to pay more. That I agree. You made that argument before the district court. But where did you make the upfront monies argument before the district court?
I don't believe that argument was made before the district court, because at the time that we were briefing the judgment interest issue, the parties presented the briefing to the district court on the exclusion, not on the issue of interest, because the parties clearly from the litigation agreement did not contemplate the imposition of interest. And then the magistrate all requested that the parties brief the issue of interest. And so I don't believe it was raised at the, and at that point, when we're briefing the litigation interest issue, the court has already determined that
Didn't the district court ask you for briefing on interest?
on interest, correct.
And when the district court asked you for briefing on interest, did you make the upfront monies argument in the briefing that the district court asked for about interest?
We did not at that point, because at that
So
point.
why isn't that a massive forfeiture?
Well, I believe because at that point, the issue there is that the coverage had already been determined. And so the argument of that the upfront monies, well, and so the argument that I'm presenting here in the kind of the comparison I'm making, or the outline of the potential outcomes here, is that if no coverage had been determined, that there's no, the litigation agreement clearly states that there would be no recovery on those funds. That was not raised at the district court, because at that point, coverage had been established. The magistrate Auld had determined that the exclusion was not, did not apply. Finally, the consent judgment, looking at Joint Appendix 241, the consent judgment itself, had it ever been entered, which it would not have because the upfront monies were paid, the consent judgment does not contemplate the payment of interest. There's no award of interest. If the consent judgment had been brought before the underlying court in the state court action, there's no, and entered, there's no accounting for judgment interest in that consent judgment itself. There's a very similar scenario that the North Carolina Court of Appeals had addressed on a in an unpublished opinion in Winters v. Allen in 2004, the parties resolved their litigation with a pre-suit or a pre-trial settlement agreement, leaving open the issue for litigation, or the issue of judgment interest for the court to decide on a motion. The court issues that the payment of the full policy limit was judgment interest would have been applicable to that, and the Court of Appeals reversed that, saying that there's no authority that the settlement changed the requirement in the policy that a judgment be issued against an insured, which is the same requirement that Harford has in its policy, which is that a judgment be entered against the insured, and that is what triggers the obligation for Harford to make a payment under the policy. So we would argue that, as Mr. Bulford said, that the auto exclusion does not apply. If the auto exclusion applies to bar coverage, if the auto exclusion does not apply, we would request that the court reverse and remand the issue of judgment interest.
Judge Berner, anything else? Judge Goodman? Thank you very much.
Thank you, Your Honor.
All right, we will hear next from Mr. Cohen.
Thank you.
Did I say that correctly?
Cowan.
Cowan, thank you, sir.
May it please the court. My name is Coleman Cowan. Along with my colleague Caitlin Fudge, I represent the appellees in this matter, Ms. Erica Chambers and her two daughters, who for purposes of this case are known by their initials JH and EH. Ms. Chambers and her two daughters are with us here in court today from North Carolina. This case initially presents the court with the question of whether or not an insurance policy's exclusionary clause, which does not explicitly include claims involving entrustment to others, nonetheless excludes coverage for such claims. Appellants in this case asked the court to rewrite its insurance policy and insert entrustment language in the auto exclusion, where Harford chose to leave it out, despite including that language in a separate exclusion in the same policy, as well as in an auto exclusion in a separate commercial policy issued to the same insured, Big Boss Construction. The district court held Harford to the terms of its insurance policy and gave meaning to all of the provisions in the excess umbrella policy, and held that the auto exclusion did not exclude claims for negligent entrustment.
Well, but the auto exclusion is not written in terms of which torts are covered. It's written in terms of what conduct is covered. And clearly, part of the conduct in this case is that somebody drove the car and injured your clients.
Yes, I would agree that somebody drove a car and injured our
And
client.
that's what, and the policy says if somebody drives a car and injures the client, that's excluded, right?
Not in the context of the entire policy, which North Carolina cases consistently tell us courts look at the entire policy.
So your colleague cited a case that actually I don't think he cited in his brief, but I think you might have cited in yours, Farm Bureau Mutual Insurance versus Martin, and says, no, that's not the case. If the provision is clear, you don't look to the full policy, you just look to that provision. I think that's what he cited that case for. What's your response to that?
I am not familiar, Your Honor, with any case in North Carolina which has said that the court should do what appellants ask this court to do, and that is look at a single provision of an insurance policy in isolation and do not consider any language outside that isolated provision, and do not consider how that provision is used in the context of the policy. No North Carolina reported cases have done that, have done what the appellants asked this court to do.
Well, they say Wachovia does that. Why? What would you have us say about Wachovia?
Okay, the interesting thing about Wachovia, and there's another case from the North Carolina Supreme Court, Woods, 8 years later. Wachovia was in 1970, Woods was in 1978. Both of those cases, as they recite the rules of construction, say that the provision has to be construed in context. And in fact, both the Wachovia court and the Woods court did just that. The issues in both of those cases were medical payments coverage provisions, and whether or not they could be stacked with different automobile coverages within the same policy. The Wachovia court held that they couldn't, and they did that because they compared it to a limits of liability, a separate provision in the same policy, and concluded that they could not be stacked. What the Wachovia court did is they looked at the provision in the context of the entire policy. 8 years later, the Woods Court, the North Carolina Supreme Court in Woods, did the exact same thing on a similar issue, but came to a different conclusion because there was different policy language. The same issue in the issue in that case was the same, whether or not medical coverage payments could be stacked when multiple cars were insured under an auto policy. In that case, there was a separate applies separately clause in the auto provision, with which the North Carolina Supreme Court said, once we look at the entire contract and look at the medical payments coverage in context with the applies separately provision, it applies separately, and they can be stacked.
So it's interesting, because Wachovia actually says, terms must be interpreted in the context of the entire policy unless the immediate context requires otherwise. So this unless the immediate context requires otherwise language, I don't know what that refers to, but could it possibly refer to a situation like here where the explicit exclusion actually covers automobile accidents? This was an automobile accident, so wouldn't that be a situation where an immediate context requires otherwise?
I agree with your logic, but not your conclusion, respectfully. The context in this case, we have an exclusionary clause which does not include the entrustment to others language. It is included in other provisions in that same policy, and a separate policy issued to the same insured. This is the issue that courts across the country have been grappling with for decades, from the Seventh Circuit and the Standard.
When you say this is the issue, what is the issue you're speaking of here?
The issue is this: whether or not the language ownership, maintenance, operation, and use implicitly also includes the language entrustment to others. This is what the courts have split on.
So do you agree with, because I asked the folks on the other side, are you aware of a case that's like this one? So, and by like this one, what I mean is the auto provision does not say entrustment, but other provisions involving aircraft and watercraft do say entrustment. Do you know of a case that confronts that fact pattern?
I am not.
Okay.
And I have searched.
I imagine you have.
And I am not, frankly, Your Honor. The courts that have dealt with this issue are looking to see what the policy language requires. What was the intent of the parties? Or in North Carolina, what the standard is, what a reasonable insured would understand the coverage to be based on the entirety of the contract. The courts in the Standard Mutual case in the Seventh Circuit cited by the appellants, as well as the Douglas case out of the Tenth Circuit, the Cone case from the New York Supreme Court, and the Oberlin case from the Supreme Court of Kansas, they all look at this issue that I mentioned earlier, and that is whether or not the entrustment language is specifically included or implicitly included within.
So, can I ask you this? In order to rule for you in this case, do we have to decide what would happen if the aircraft and watercraft provisions did not include the entrustment language?
I don't believe so, because those aren't the facts of the case.
Right. The reason I say it is, look, if we didn't have this language in the aircraft and watercraft provisions, it strikes me that the builder's case is a real problem for you, like a big problem for you. Now, I don't know if that matters here because we do have that language, but I mean, so could you address why the bill? So again, now I want you to imagine this contract does not have that language in the aircraft and watercraft. If that were true, why isn't builders really bad for you?
It would make the issue much, much closer. I agree with that.
Wouldn't it mean you would lose?
Not necessarily. We'd still argue that the negligent entrustment claim is a different tort. It involves a different action of entrusting a vehicle to somebody else. It's the reasoning of the Tenth Circuit in the Douglas case, as well as the New York Supreme Court in Cone.
But with respect, this is a diversity case. I'm not really sure why I care what the Tenth Circuit says. I care what the North Carolina Supreme Court says, and builders is a decision of the North Carolina Supreme Court.
Exactly, and this court is armed with something that the builder's case did not have, and that is clear evidence that Harford Insurance makes a distinction between ownership.
Right, but
maintenance, and use.
that's relying on the fact that we then that we've got this in the other provisions. I'm talking about the hypothetical where we don't have these other provisions. What's the argument that you wouldn't lose there?
That cases in North Carolina, specifically the state capital case and the Davis case, construe provisions differently depending on whether or not they are in they are in a provision extending coverage and are construed liberally, or are they in a provision excluding coverage? They are construed narrowly. I agree and I concede, Your Honor, that the argument might be much more difficult on our side if the aircraft and watercraft exclusion were absent, and if the auto exclusion in the commercial policy underlying this policy was absent. If it was just viewed in isolation, yes, it would be a much more difficult argument. But that is something that the North Carolina courts tell us you do not do. You evaluate the policy as a whole, and you give meaning to all provisions within the policy. And again, Your Honor, a critical distinction in this case is that Harford has told us they make a distinction between entrustment to others and ownership, maintenance, operation, and use.
So I'm assuming there was a separate automobile liability policy, given this exclusion, is that right?
That is correct.
And was the accident covered under that policy by the same insurer?
A different insurer to the tune of $100,000, yes.
Doesn't that suggest the insured understood that this didn't cover auto accidents and they needed another policy to do that?
No, Your Honor. From a reasonable insurer's perspective, if they received these two commercial policies from Harford, one, the commercial general policy, which is not at issue in this case, it is in the record. The commercial general policy has a auto exclusion that clearly by its terms excludes entrustment to others. It includes that language. Then if you look at the excess umbrella policy, which is the one at issue in this case, the auto exclusion is separate from the aircraft and watercraft exclusion, which includes the entrustment claim, but the auto exclusion does not include that language. So if you are a reasonable insured looking at the contracts that Harford has handed to you, a reasonable understanding would be, once I get into the coverage under the excess umbrella policy, which by its terms explicitly states it covers things that are not covered by the underlying commercial policy. The reasonable interpretation by a reasonable insured would be that they are covered for negligent entrustment claims like the one in this case.
Would you respond to the question I asked about your colleague about the burden of proof on this issue?
Yes, we have the burden of proof on establishing coverage, and then the insurer has the burden of proof of establishing an exclusion. And that raises the issue of the appellant's occurrence argument, where they argue you can't have the same. It's either an occurrence or an exclusion, or it's not an occurrence, and then you have the exclusion. A critical point to raise here is one that we raised in our brief, is that this is an entirely new argument on appeal. If you read Judge Auld's opinion, you will see that it does not reference this issue at all in any way, and the reason it doesn't reference it is because it was never raised.
What issue
in the
wasn't
trial
raised?
court.
I'm sorry.
The occurrence argument. Appellants argue that all this arises out of a motor vehicle collision. This is the language that triggers coverage, and if it triggers coverage, it should also then trigger the exclusion.
This is sort of their like approaching formal logic point that something can't be both X and not X at the same time?
That's correct, Your Honor. That's correct. And so I want to make 2 points on that argument. First is one I just made. This is an entirely new argument raised for the first time on appeal, which Fourth Circuit precedent clearly holds that argument is waived absent exceptional circumstances, which I would contend are not present in this case. Even if the court was to entertain this argument, we know from the state capital case as well as the Davis case in North Carolina that the exact same language can be interpreted differently depending on whether or not it is in a provision extending coverage as opposed to a provision excluding coverage. In both of those cases at issue, the language at issue was the arising out of ownership, maintenance, operation, and use language. In both of those cases, the North Carolina Supreme Court held that that language in the policy extending coverage triggered coverage because they construed it liberally as a clause extending coverage. But the same language in the exclusion didn't apply because the Supreme Court construed it narrowly. So again, this argument we would contend is entirely new, has been waived, but even if the court considers it, the North Carolina Supreme Court can consider the same language differently depending on whether or not it's in a coverage provision or an exclusionary provision. If I could, I want to make sure I have time to address the interest issue. In this case,
Could you specifically address the $2 million cap issue, which is, I think, the one interest argument they've actually preserved?
Right. That clause of the litigation agreement just established the amount that would be tendered under the coverage for the policy, depending on how the district court ruled on the two policies that were at issue. What was clear, though, is that in the following paragraph 6 in the litigation agreement that's already been referenced earlier, the litigation agreement by its terms clearly states that it, quote, in no way relieves the Harford insurers of any obligation to pay money under the insurance policies. If you look at the coverage language in the Harford policy, it states that it applies to any judgment in both the pre-judgment provision as well as the post-judgment provision. Addressing the consent judgment issue, again, we would contend that this issue has not been properly preserved, but as Judge Auld ruled in the district court, it doesn't matter because it is still a judgment, a consent judgment that was entered into by all parties. And again, we look to the covering language in the insurance policy, which clearly states pre-judgment interest awarded against the insured on their part of any judgment covered in this policy. The post-judgment interest provision, all interest earned on that part of any judgment within the limits of insurance.
So what do we do with this language? In no event shall Hartford insurers be obligated to tender more than $2 million under the big boss excess policy. It's right there in the agreement.
Right. And again, that is, goes to the amount of coverage designated in the policy. But the policy also goes on to state that payments under that section of the policy do not reduce, excuse me, this is the interest. That the interest section states that it applies on top of.
But there's
the
no
coverage
interest
issue.
section in the agreement, is that right?
What we wanted to preserve in the agreement, and what I believe both sides agree on, is that the litigation agreement does not change the terms of the insurance policy, which clearly provides coverage or indemnification for both pre-judgment and post-judgment interest. So one final point I'll make on the consent judgment issue and whether or not the appellants contend that one of the reasons interest can't apply to it is that it was never filed. If you read the interest statute in North Carolina's 24-5, subsection B, there are two sentences. The first sentence is the one that applies to this case, and it does not require filing of the judgment. It simply states, excuse me, it states that in any action other than contract, which is what this is, any portion of a money judgment designated by the fact finder as compensatory damages bears interest from the date the action is commenced until the judgment is satisfied. That's the sentence, the provision that applies to pre-judgment interest in this case, which is controlled by North Carolina law. There is no requirement that the judgment actually be filed or entered. That is brought home by the next sentence, which doesn't apply to this case, but does require that the judgment actually be entered under Rule 58 for things such as attorney's fees. It reads, this is how it reads. Any other portion of a money judgment in an action other than contract except the costs bears interest from the date of entry of judgment under General Statute Section 1A-1, Rule 58, which is entry of judgment.
So under your version of things, does interest start to run when your clients filed suit or when the declaratory judgment action was filed?
It begins to run when we filed suit back in October of 2019, because again, if you look at the rationale for why North Carolina courts award pre-judgment interest, it is to compensate the injured person for the, you understand this, the lack of the use of the funds, whereas the other side has had the benefit of that. And what the courts do is that they look to the date that the claimants demanded payment for it, which is the date they filed the lawsuit. In this case, that's in October 2nd of 2019. So, in conclusion, Your Honors, the district court on the coverage issue held Harford to the language it selected and gave meaning to all provisions of the Harford policy and held that the auto exclusion did not exclude negligent entrustment claims. Appellees asked this court to do the same. On the coverage issue, on the interest issue, the district court held Harford to the terms of its policy and the terms of the litigation agreement and awarded pre-judgment and post-judgment interest. Appellees asked this court to do the same.
Thank you. Mr. Belfer, you have some rebuttal time.
Your Honor, just a couple points in the 2 minutes that I have left. First, if I can address the question of the Wachovia case, and Judge Berner, you sort of took the words out of my mouth as I was writing down immediate context. The Wachovia case says that where immediate context in which words are used is not clearly indicative of the meaning intended, resort may be had to other portions of the policy. The immediate context of the bodily injury, or excuse me, the auto exclusion here shows that bodily injury arising out of ownership, use, or operation of a vehicle is clearly excluded. Turning to the cases that were specifically cited, the Woods case. The Woods case actually has an additional bit of language which is important for this court, which is that that courts may not, under the guise of ambiguity, rewrite the contract or impose liabilities not bargained for. What was bargained for here was a excess commercial general liability policy, not an auto policy. The Standard Mutual case that has been discussed, I know that's a Seventh Circuit case, but what it does also say is that 28 of the 31 jurisdictions to have addressed the question of whether this exclusion is unambiguous have found that it is unambiguous.
And when you say this exclusion, you mean this exclusion in a policy?
The auto exclusion, Your Honor.
Okay.
Correct.
Not this actual policy, a policy that's somewhat different from this actual policy. Now, I know you argue it doesn't matter, but like, it's not this policy.
What I would say, Your Honor, is those cases don't discuss whether other exclusions, be they asbestos or otherwise, have any impact on an unambiguous exclusion for the use of an automobile. Turning to the judgment interest issue, there's just two follow-up points, and I have daughters who love the movie Wicked, and this definitely feels a bit like the no good deed goes unpunished part of the argument. This was a settlement agreement that very clearly says, under on Joint Appendix, page 209, that in no event will Harford Mutual be obligated to pay more than $2 million if we lose. We reached this agreement because it was a more efficient way to get these underlying plaintiffs an answer they needed on available coverage. If the conclusion is that pre-judgment interest is now going to be imposed by a federal district court on an underlying state court action where a settlement has been reached, it has a real possibility to stifle the ability for insurers and for underlying plaintiffs to work collaboratively to find economical and judicially efficient results. And that should not be overlooked as this court is weighing the substantive arguments that we've talked about today.
Thank you, counsel.
Thank you.
Okay. We will come down and greet counsel and then have an extremely brief recess.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. Okay. I believe our third case from the day is number 234031, United States versus Johnson. And I believe Ms. Quattrone is up. Did I say that correctly?
You did. Thank you, Your
Awesome.
Honor. May it please the court. Good morning, Your Honors. My name is Elena Quattrone, and I represent the appellant, Mr. Arlie Ray Johnson, along with my co-counsel here, Ms. Sarah Hall. This is an appeal from a jury verdict for Mr. Johnson's position that after a 10-day trial and 7-day jury deliberation, he was convicted unjustly due to improper tactics by the government and rulings by the district court that were not harmless, for which he is now currently serving an unjust 78-month sentence. Mr. Johnson respectfully requests that this court vacate his conviction and remand.
Well, on the issue of prosecutorial misconduct,
Yes, Your Honor.
isn't much of what you're arguing there simply vigorous advocacy by the prosecution?
Yes, Your Honor. However, I think what we establish in our papers and what we're prepared to address today is that there's vigorous advocacy, but then there's also crossing the line. And here, one of the themes that we want to discuss
Can I
is
just, as a
government.
preview though, it's not whether they crossed the line, it's whether they clearly and obviously crossed the line, because this claim is forfeited because it was never raised before the district court. Is that right?
Are you addressing, Your Honor, the?
All the prosecutorial misconduct allegations, where were any of those raised before the district court?
We are arguing for plain error.
Okay,
Your
so it's
Honor.
not even enough that they crossed the line. Under prong 2 of Alano, they have to have clearly and obviously crossed the line, right?
Correct, Your Honor, and we believe we meet that standard
Okay.
across our arguments. And as Your Honor points out, there are two themes addressed in our papers, that of government overreach and prosecutorial misconduct, and inconsistent and unduly prejudicial rulings by the district court that created reversible error. Now, to address Your Honor's point on the question of the difference between zealous advocacy versus the plain and obvious error of crossing the line here, we believe that the prosecution's that the activities that occurred at this trial were reflective of the prosecution's effort to do anything to convict the lowest person involved at this company that held a position of power, so as to secure a conviction unjustly.
So let's start with something tangible. The first thing the prosecutors did that was clearly and obviously improper was blank. What is the first thing they did that was clearly and obviously improper?
We would say their failure to correct the untruthful testimony of its witness, Femi Tamobi, Olafwo Femi Tamobi, in which,
Well, wasn't that cleared up on cross-examination?
Your Honor, though this witness was
Well, but that
impeached.
happens all, I mean, you go try cases, this is the kind of thing that happens every day. Somebody sort of stretches their testimony, and then the other lawyer comes in. That's what you want when you're a defense lawyer. Let me prove this guy's a liar.
Yeah, and I understand your point, Your Honor, and I believe, yes, we were successful in impeaching Mr. Tamobi on a very material fact to Mr. Johnson's mens rea.
Of whether, whose idea it was to call the FBI.
Correct, it was Mr. Johnson's.
Well, okay.
But I think
don't,
that this point goes directly to not only the witness's credibility and that he was willing to lie on the stand, but also to the point of Mr. Johnson's knowledge and what he knew at the time and directly to his mens rea, which we believe is a material fact that the prosecution was aware of. To impeach Mr. Tamobi, we used the very grand jury testimony that the prosecutor took, or not this prosecutor, but that the government took. So they were aware of Mr. Tamobi's position prior to being examined on this point. And we would point to the Supreme Court case Napu v. Illinois, which sets forth that the prosecution has an obligation to set forth truthful testimony, which was also echoed in the recent case, Supreme Court case, Glossop v. Oklahoma, just decided.
But so in
February
Napu or
25th.
any of these other cases, did after the prosecutor did the thing that was allegedly misleading, defense counsel get up and show in front of the jury the misleading thing they had just done? Did that happen in Napu?
It did not, Your Honor. However, we still think that given the weight of this specific testimony and the fact that it could be impeached on cross-examination, which it was.
However, there's a nuance there that perhaps the jury doesn't fully appreciate or fully understand, given the nature of trial. And I would also point out that though we were successful in impeaching Mr. Tomobi on cross-examination, the way in which we did, he was very cagey, and I think we provided excerpts in our brief of the response. The district court did not that we requested, but we did not read into the actual testimony from the previous grand jury transcript. So in the fact that Mr. Tomobi was being dodgy in his responses, it didn't provide a full picture of actually the weight of what his testimony was prior to these inconsistent
Okay,
statements.
so
made.
the second thing the prosecution did that was clearly and obviously improper was what?
We believe that the prosecution engaged in misconduct during Mr. Johnson's sentencing hearing when they advocated for a sentencing enhancement, and in so doing violated Brady.
Well, they didn't get it.
So it wasn't the actual request for the enhancement that was the issue. The issue was, in so advocating for this enhancement, they revealed that they viewed other alternate subjects or alternate suspects, alternate perpetrators, as being involved in this crime.
How is that possibly Brady material? Your brief just asserts that that was Brady material? I have no idea how that's Brady material.
Brady sets forth, Your Honor, the need for disclosures for exculpatory evidence.
How is the fact that other people might have been involved in this crime exculpatory?
It was the particular person named, Your Honor. The prosecutor named an individual by name who was one of Mr. Jolly, the lead person involved in this case, which was one of his close friends and confidants. He was a person that Mr. Johnson actually even joined the Postal Inspector Campbell and the government in a recorded phone call to try to apprehend Mr. Jolly. This was a person who knew Mr. Jolly, who was aware of his whereabouts, and who potentially could have had information that would have helped Mr. Johnson's
Whoa,
defense.
potentially, and that's Brady material?
Well, we believe it's Brady material also, Your Honor, because in this case, what's a unique aspect of this case is following the motions hearing prior to trial, the court ordered that the government issue a Brady disclosure letter, given the voluminous discovery in this case. And this is a unique fact that we haven't seen in many other cases. And in that letter, which is in the JA at, I believe, JA 0242, there's no mention of these alternate suspects. And we believe that had this information been revealed, it just shows the prosecution viewed other people as being potentially criminal liable.
And I still don't understand how that's exculpatory under Brady.
I think it's exculpatory under Brady, and our position is that these are people that might have had additional information that had Mr.
Brady is
Johnson
not
been
a
aware.
general disclosure rule. Brady is a rule that says you have to disclose exculpatory or impeaching information, and I don't see how other people might be criminally responsible is exculpatory or impeaching.
I think it's due to who these specific individuals were and the information they might have held, and the support they might have been able to give had we been aware that this is how the government viewed them, that they were actually keeping Mr. Johnson in the dark about what was going on at Smart Partners, which goes directly to his argument that he had no knowledge, and his position that he has no knowledge about the activities that went on at the company.
So your point is not that any one of these alleged four things of misconduct itself is a cause for reversal, but rather that we can't view them individually, we have to view them collectively, and collectively they spell out a government that's out to get your client.
That's correct, Your Honor.
Well, they were out to get your client, weren't they?
They were, Your Honor, but we maintained, and Mr. Johnson still maintains his innocence, that he knew nothing about what was going on at this company, and we truly believe that this is an individual who was wrongfully convicted due to
Do
not.
you think this misconduct thing is your strongest argument in this case? And
I
if
think
not,
that-
what is your strongest argument?
I believe that we have one more prosecutorial misconduct argument that is particularly strong, that if I may preview to the court, it's the argument on the willful blindness instruction. And
Well, in every Ponzi case I've ever tried, they always ask for a willful blindness instruction. And the reason they do is, well, you know, if somebody on the jury thinks, maybe he didn't really know exactly what was going on, they can fall back, the jurors can fall back on this. And it's an accurate statement of the law, and it's an accurate theory, right? If they had gotten up and argued, if you don't think that he knew about this, he still can't escape it because of willful blindness, then you wouldn't have this argument, would you?
Well, Your Honor, I believe that the standard calls for that there be, that the defendant has to assert guilty knowledge, but also that the evidence supports an inference of deliberate ignorance. And we don't believe that any evidence offered in the case indicates that deliberate ignorance was there.
Well,
So-
some judges, like me, wouldn't grant that in a case like this, but others, I think it's pretty routine. It's always tendered.
I think we fall back on the point, Your Honor, that this was an incredibly close case. Again, given by the fact that the jury deliberated for almost 7 days, almost as long as the trial itself, they required an Allen charge to reach a decision. And therefore, any extra opportunity to convict, they might have been able to
But your
take.
argument on this point, I understand, is that you accuse the government of being inconsistent, and I don't understand what the inconsistency is. So what I understand the government is saying is, we believe that he knew, and we believe the evidence is more than sufficient to conclude that he knew. But we also know his defense is, I didn't know, and it's possible that some member of the jury might believe that, and therefore, in a sort of belt and suspenders, we would also like you to tell the jury, just if the mere fact that he technically didn't know X does not mean he's scot-free if the only reason he didn't know X is because he buried his head in the sand. I don't see what's inconsistent about the government saying both of those things. Our view is that he knew, but we recognize his argument is that he didn't. So in the event a jury believes him when he says that, we'd like this instruction. I don't see any inconsistency with the government's position at all.
I think it just goes to, at sentencing, when the government admitted that they only ever viewed this case.
Yes,
as
that's
one.
what their view was, but they're not stupid. They recognize that at least one juror might have thought differently, and they wanted an instruction to deal with that possibility. I don't see what the inconsistency is.
I understand, Your Honor. I still think, though, that this gave the jury on an incredibly close case where there was obviously some doubt raised, that it gave them an easier way to convict.
That's
than
what a
if
willful
this-
blindness instruction does.
Well, and that's why, and that's why, Your Honor, we argue against that.
Well, going back to my question
sure.
about your strongest argument, if we don't find prosecutorial misconduct, you've got 4 other arguments.
Sure.
About Jolly leaving, about the Soweto article, cash deposits, and Marindi in uniform. Which one of those do you think is your strongest argument to get this verdict reversed?
Sure, Your Honor. I would focus on the improper limitations on the cross-examination of lead case agent, Postal Inspector Campbell. Here, the district court improperly limited the defendant's cross-examination of this key government witness, who, again, wasn't just a government witness. He was the lead case agent on the case. He was the witness through whom the government got in most of their evidence. And it was limiting his cross-examination on the circumstances of Mr. Jolly's leaving the country. And this is important because Mr. Postal Inspector Campbell committed in writing that that Mr. Jolly fled the country. And we maintain that he did not flee, that to say that he fled is a lie.
Because a person who had no legal authority to detain him didn't tackle him in the airport? I just don't understand how this isn't, why is this not fleeing?
Well, because to the definition of fleeing we offer is somebody leaves unbeknownst to anyone. No one knows where they're going.
Well,
And
but,
this-
this guy knew the cops were looking into him about this whole Ponzi scheme, and then he said, I'm going to South Africa.
Well, and he was apprehended.
That's fleeing.
We argue, Your Honor, that he was permitted to leave by Postal Inspector Campbell, who approached him and exercised a search warrant on his person at the airport and then permitted him to board a one-way flight to South Africa.
You mean he permitted to leave, by permitted to leave, you mean did not unlawfully detain? That any failure to unlawfully detain constitutes permitting to leave?
I don't necessarily think we're not offering this argument to challenge, what's required to prevent somebody from leaving the country. We're offering this argument to say that we think it's inappropriate to categorize it as fleeing versus just he knew he was leaving. And I believe the government made other arguments that they didn't know where he was. They knew where Mr. Jolly was. He flew to South Africa and they let him do it. I think the other part here where this becomes an issue with our restriction in being able to ask or to raise credibility questions of Mr. Campbell on this point is that to further compound the error, the district court then granted the government's request to include in the jury instructions the overt act that on or about May 30th, 2019, Mr. Jolly fled the United States.
So this was tried in Maryland?
Correct, Your Honor.
Do they always give a list of the possible overt acts up there?
I'm not sure, Your Honor. My co-counsel would probably know better than me. I do recall that there was some debate over which overt acts to send back, and this one was included. And we believe that by being permitted to provide this overt act back, it was an inaccuracy that was permitted, and though we were restricted from cross-examining on that point, it still went back with the jury. So there was an inconsistency in the ruling where we maintained that that point should not have been gone back to the jury.
Well, why couldn't you just instruct the jury that they have to find an overt act by one of the conspirators to reach the goal of the conspiracy and let them decide what the overt act is?
I think that's what we would have preferred, Your Honor, but at the end of the day, this particular overt act went back to the jury without our being able to question Mr. Campbell on this point on cross-examination, which would have went directly to his credibility. And I see I'm over time, Your Honor, so I'm going to step down.
Thank you very much. You'll have some time in rebuttal.
Thank
Thanks.
you very much.
Mr. Moore.
Good morning, Your Honors, and may it please the Court. Brandon Moore on behalf of the United States. In just 1 year, Mr. Johnson and his co-defendants defrauded victims out of $28 million of their hard-earned savings. As we heard on opening, this was an extensive trial. It was 9 days of testimony, over 24 witnesses, and then there was an additional 9 days of deliberation. And at the end of this, the jury held Mr. Johnson accountable for his crimes.
Didn't Mr. Johnson provide information to the government over the course of months? In fact, I think I read in the record that Mr. Campbell actually was annoyed that Mr. Johnson kept calling so much, and he invested $1 million, I guess, dollars of his own money, or I'm not exactly sure how much. I mean, I am sympathetic to the statement by your colleague that this is a strange prosecution. Much of the evidence of the government came from Mr. Johnson himself. He even encouraged his coworkers to call the FBI.
I would agree that Mr. Johnson took several actions after the fact to call the investigators' attentions to several pieces of fact. I think we disagree as to what the motivation behind that was, and then also how helpful some of that was. Like if the background to calling Inspector Campbell incessantly and wanting to cooperate is that we had actually asked for him to get in touch with counsel to do that during the normal channels, but he didn't want to do that. I think that it's fair to construe that as just being, I believe our position on that would be that that is indicative of probably like a, for lack of a better analogy, like a CYA after the fact. And then a lot of these things are like that. So if you're looking at when allegations are brought to Mr. Johnson's attention, the newspaper articles, the hit from South Africa, the investigative steps that he says he's going to take, when he actually falls through on doing, are two different things. The assurances that he gives people, and then the actions that he takes with regard to the Ponzi scheme and how he continues to sign people up and benefit from that are two different things. And so this all of a sudden, we're caught, and now I'm going to give the appearances that we're going to go through all the motions, so I'm trying to help the government. That's different. And I think an indicative of that, too, is how he helps to try to identify where Mr. Jolly is in South Africa. I believe our position below was that a lot of that information that we brought it to our attention was not accurate, and then we had even interviewed, was it Ms. Cargbo, and still were not able to apprehend Mr. Jolly at that time.
And why did the government limit the cross-examination of the Inspector General? It seemed clearly to go to the credibility of Mr. Campbell.
Sure, and I think the point here is, I don't think we disagree on the facts, right? The way that my friend from the other side describes the facts, I don't think we disagree on those. There was a one-way ticket out of the country. This was within 10 days of us initiating our investigation. This was within days of the accounts being frozen. I think Mr. Jolly has a clear understanding that now's the time to leave.
So why wasn't he permitted to ask questions about the fleeing, or whether it was a fleeing or a letting go?
Because below, the position taken below, as I understand it, is to bring about an understanding of the facts. It's just not representative. I think the first is that Mr. Johnson wanted to present some sort of narrative that the government either benefited from Mr. Johnson leaving or that we let him leave, and that's certainly not the case. It's just Heitens had said in opening. It's that we had no legal mechanism to let him leave, so it's trying to paint an accurate picture of what was happening. And then the second point too is I think there was a narrative that Mr. Johnson wanted to present that somehow he wanted to get Mr. Jolly back to the United States more than the government did, which is also inaccurate based on the facts that we had. And so I think the judge actually called this. It's to prevent this sort of sideshow. We're going to go down just a sideshow that's going to lead to any number of conclusions. The first is talking about Inspector Campbell's credibility. I think it's a totally reasonable conclusion to draw based on the uncontested facts that flight is what Mr. Jolly is actually doing. And then cross-examination on that would have only brought that to light. The second part is that.
Right, but he wasn't allowed to cross-examine him on it, so he wasn't permitted to bring it to light. And that was his argument, was whether or not Mr. Campbell was credible in making that assertion.
True, but it's the district judge is also within his discretion to limit the type of testimony that's on a sub-issue, which is
The credibility of a key witness of the government, that's a sub-issue?
not the credibility. See, the credibility, I think, if I'm reading the record accurately, is the thing that they're arguing now. That's not what they were arguing before when we were talking about limiting the cross-examination on that. I think what they were also asking too is that the government should have or was in a position to get an arrest warrant, which also would have triggered an additional instruction on whether or not it's relevant what investigatory steps that the government took. I think there was no line of questioning that was going to be like germane to the rest of what Mr. Johnson's defense was in light of the broader evidence that was being
So,
brought
Mr.
in.
Moore, picking up on that, let's say, because it's true, that I'm very sympathetic to the district court's rationale for limiting the cross-examination, and at least on abuse of discretion review, I'm inclined to think it's fine. Just to say, like, we're not going to have debates about whether you can legally arrest someone when you have a search warrant, and we're not going to have debates about whether the government could, like, I can totally see the district court's rationale. This is all collateral. But what I don't see you can do is because we're not going to get into what happened at Dulles and what the legal basis of doing things at Dulles were, because as you say, it's a collateral issue. Totally sympathetic. But it seems to me that once you do that, you can't send Flea back as an overt act. That you either have to choose, either we're going to litigate the circumstances under which he left, or we're going to tell the jury fleeing is an overt act. But I don't see how you can do both of those things.
Oh, and that's exactly what happened.
Well, that is what the district court judge did. So I'm concerned that you can't do both. So I think if I said to you my hypothesis is the district court was totally within its discretion to limit the cross this way, but once you do that, you can't send flight back as an overt act because you can't prohibit the defendant from cross-examining about the circumstances where a person left and then say it's an overt act that he fled.
True. Thank you for raising that point, Judge Heitens. And what actually happens is there's a colloquy or there's a conversation at the bench between the court and the parties where there's a discussion on whether to allow that overt act in the back. And the judge makes it clear, I limited cross-examination on this point, but then you brought it out. You brought it out in your witness, Ms. Cargbo, and then you brought it out with Mr. Johnson on the stand. Part of their core defense is that even though they're not using the word flight or flee, but then Mr. Johnson, or that Mr. Jolly left, essentially leaving Mr. Johnson holding the bag. So they opened the door to that.
Or reopen. You closed the door, then they reopened the door is the idea?
It was open, it was closed, and then they opened it again. So at that point, that's when it went back. And there was an entire discussion with the bench before allowing this in. So again, if we're talking about arbitrary and irrational, no. There was a full-blown discussion over it. There was a back and forth. The judge considered all of the evidence that came in. He considered his prior ruling. And then only after that did he allow the overt act to go back. I would also mention that there were several overt acts that were alleged as part of that wire fraud conspiracy, and then Mr. Jolly fleeing is probably like the least significant of those. So,
But that'd be a harmless error argument.
yes, it is.
So what about this newspaper article?
Sure.
That strikes me as extremely prejudicial. They couldn't cross-examine anybody about it, and who knows whether it's true or not. I don't understand why that, I got no problem with the authentication problem, but I don't understand why that isn't unduly prejudicial and essentially a form of hearsay.
Do you mean like the exhibit itself coming in, or just testimony about the article?
Well, their whole discussion about the Soweto article, I don't understand why an article from a newspaper in South Africa is admissible in a trial in Maryland.
Correct. And then to my understanding, and I could be wrong, I don't think that there was any discussion about limiting the testimony surrounding the article itself or limiting cross-examination on the article itself. I think it was just the exhibit. The physical exhibit was the issue below, I believe.
Well, that's right. If something's in writing, it's entirely believable. That's
Also-
what I was taught.
On the one hand, and then on the other hand, it's also believable if multiple people testify about it and they corroborate each other. But to that point, again, it was not elicited for the truth of the matter. It was elicited for the impact that it had on Mr. Johnson, and then what Mr. Johnson then did with that, and then putting Mr. Johnson on awareness that.
And just to be clear, once it's not offered for the truth, it's not hearsay, right? That's
Correct.
the definition of hearsay?
That's actually correct.
So-
It's technically not hearsay, and we got an instruction.
Not technically not hearsay. If it's not hearsay, it's not excluded by Rule 802.
I was trying to be nice. It is not hearsay.
So the government's theory is that he was not, he can't say he didn't know about this because he had a newspaper article from South Africa that accused this guy of something. Is that what the government's use of this was?
I don't think not directly as I believe the question is asking. It was not presented as there is fraud in South Carolina, or South Africa, therefore there is fraud here in Maryland. It was not presented
No,
in
but
that way.
he knew that this guy was a shady character and was liable to steal money.
Well, let me take a step back, because the article in and of itself is insignificant without the context of multiple people bringing his attention to it, who like multiple employees of the
So the
company.
employees went and said, look at this article, what do you think about it?
Yes, as people within the company, either employees or associates, are becoming aware of this article, they're bringing Mr. Johnson's attention to it because they are themselves worried whether there's something impermissible going on in the company. And you have to look through this through the lens that at the time this is happening, customers are coming in complaining that they're not getting their investments, employees are complaining that they're not getting paid, checks are bouncing, right? So it's part of a global scheme of there could be one explanation for why all of these things are happening. It could just be mismanagement of funds. But then also, a lot of employees are kind of scared about this. And then actually, during Mr. Johnson's direct testimony, he acknowledges that if this article was running up and down the company, everybody was aware of it, everybody was talking about it, and I believe that part of their defense was when Mr. Johnson confronted Mr. Jolly about this article, it was easy to dismiss it because it was easy to conclude that Mr. Jolly was not the Dennis Jolly being talked about in the article. So the fight over the exhibit is actually because there's a photograph of Mr. Jolly in the exhibit. But then to the harmlessness point, to the unduly prejudicial point, multiple witnesses testify that that there was a picture in the article, the picture was of Dennis Jolly because I know Dennis Jolly and I looked at that picture. And they also testified as to the authenticity of the actual exhibit that was brought in. If I could turn briefly to the prosecutorial misconduct claims, I think Judge Heitens, you hit this on the head. All of these are reviewed under plain error, and Mr. Johnson just can't clear Alano prong 2. Talking about the misconduct, I believe, with the willful blindness instruction, I think there's a little bit of talking past each other here between me and the other side. I think the cases make clear, especially the cases that they cite in the reply. Leidy, Mancuso, Abbas. Our position the entire time is that Mr. Johnson had actual knowledge of what was happening in this company, but Leidy, Mancuso, and Abbas say that as soon as Mr. Johnson takes the stand and feigns ignorance, which he did, it triggers the willful blindness instruction. We were quite clear when we were going over what the injury instructions would be.
So your view is you can't get a willful blindness instruction in the following situation. The government presents evidence that someone knew, and the defense is just a reasonable doubt, reasonable doubt, reasonable doubt, reasonable doubt. That's the only defense. It's a reasonable doubt. In that situation, these cases say you can't give a willful blindness instruction, or at least maybe you can't give a willful blindness instruction.
It depends on the evidence. Like
Sure.
if the evidence literally proves deliberate indifference, then willful blindness.
Or if the defense is, it wasn't me.
Yeah.
Like, if the government says, it was this guy and he knew, and the defendant argues, it wasn't me, you can't then give a willful blindness instruction because it doesn't respond, or at least maybe you can't give a willful blindness instruction.
Yeah, I think it would depend on the context.
But your views, but once he gets on the stand and says, I didn't know, you can give a willful blindness
in
instruction.
the face of obvious signs. And so our position is that there were obvious signs. Our position the entire time is that it's obvious signs. What we put
Including
on-
this newspaper article. People keep bringing you a newspaper article saying maybe the guy you're working with is in fact a fraudster.
That through his own admission, the entire company was talking about. And he just readily dismissed based off of the word of Mr. Jolly. But once he opens the door categorically, we get it based on the evidence that we put on that there were obvious signs and that he's feigning ignorance in front of those signs. So there is just no baseline misconduct in at least asking for the instruction, which we did not do until after Mr. Johnson took the stand and put on his defense and testified. We were absolutely not going to do that until then. But then you can't clear the plain error hurdles to then do that.
Can I ask you about count 7?
Sure.
So the jury asked a question about it, and then it seems like from the record that it became clear that there was a mistake, and the government admitted the mistake, I think, but then the government didn't dismiss that count, didn't even join Johnson's motion for acquittal on that count. Why isn't that prosecutorial misconduct in and of itself?
Sure, and I think the background for this, which is borne out by the record, is I think at that point we realized there was a mistake. It was just figuring out what the right mechanism was.
Well, it seems like there were a number of mechanisms that you didn't engage. It was easy just to join. You could have just joined Johnson's motion for acquittal on that count, or you could have just dismissed that count.
But our issue was that if you look at Rule 29, there are two options for what the parties can do. A is before it goes to the jury, C is after it comes back from the jury. We were unclear as what to do in that middle ground. And quite frankly, I think the district court handled that appropriately because B kind of takes care of that. B kind of says, I'll defer. I'll defer until after the jury comes back. This is not in the record, but our intention was, you can gather from our admission that there was something infirm about the count, that we were fully ready to agree to dismiss if the jury had convicted and brought it back.
Didn't you claim in your brief the evidence arguably still could support a conviction on count 7? How? How in the world could the evidence arguably support a conviction when it's about a different person?
I think the position we were taking was Scrivener's errors. Sometimes Scrivener's errors could just be regularly.
Wow, we can convict somebody based on an indictment that names the wrong victim on the theory that that was a Scrivener's error?
I wasn't saying it's perfect, and as I said, that we were readily going to agree to dismissal had there been a conviction brought back. Our only problem was figuring out what the right mechanism was, and I think the district court actually helped the both of us there by just saying he was going to defer, which B allows us to do. A and C was very unclear as to whether that was going to happen, as to whether the parties could trigger that under 29A or C, is how we ended up there. And then moving back to the participants in my remaining time, there are two theories to seek that enhancement. One is the one that the district judge had thought going in, and then one is the one that Mr. Johnson is really leaning into on appeal. But we were actually, which is whether there are other participants, whether there are actually other criminally responsible people. We were seeking that enhancement on the basis that we thought of the scope of the people who were involved, who may not have had criminal responsibility but played a role in the fraud, which is what that enhancement allows us to do. I think where we run into trouble is because the district judge came in assuming that you needed to have criminal responsibility to get that enhancement. He started questioning us on that. And I think only after being kind of backdoored into there, we give them one name. It's Justin Rim. And then when you get to Justin Rim, there's a couple of problems with Mr. Johnson's argument. The first is that he's known about Mr. Rim the entire time. The entire time. I don't think the issue is that he didn't know about Mr. Rim. I think the issue is that that they didn't know the government's interpretation of its own evidence, which is not Brady. The second thing is they keep categorizing Mr. Rim as an alternative suspect. He is not. This is a Ponzi scheme. Ponzi schemes usually require a little bit of help in recruiting a couple of people. This is an additional target, not an alternative one. It's not that to the extent that Justin Rim is culpable, Mr. Johnson is not. It's that they both can be culpable at the same time. And that's exactly what this was. This would have just gone to like the scope even being more culpable, not less, and so it doesn't fit into the Brady argument. And unless the court has other questions, I will at least say that for the prosecutorial misconduct, I think our brief lays out just why the decisions we made at each of those junctures were appropriate, or there's no rule or legal basis, particularly for like testifying. At least for the prosecutorial misconduct, so it doesn't meet the plain error prong. In terms of the evidentiary errors, they were all small. The district court had at least a colloquy, if not a lengthy one, particularly about the article. He wouldn't let it in at the he wouldn't let the article in at the motion in limine stage. We tried to admit it initially after listening testimony on it, and the district court still said no. And then only on our third try, after fulsome testimony as to the article, did the district court let that in. That's anything but arbitrary. That's anything but irrational. And I think that's the same for all of
Did the court give a limiting
instruction on that?
He did in real time as the articles were coming in through the different, as the individual witnesses were testifying about the article. And then all the way at the end, when we were doing the final jury instructions, instructed again about the article coming.
What was the limiting instruction?
The limiting instruction was that the article could only be used for like the impression and not for the truth of the matter. If there are no further questions, I ask that you affirm. Thank you.
Ms. Quattrone, you have some rebuttal time?
Thank you. So, Your Honors, the government paints a picture of facts that are not entirely true, and I believe that this is a theme of our reply brief. And I just want to address some of the points that my colleague raised here, just to clarify what I believe is the record. In regards to Mr. Johnson's cooperation, that was not after the fact. He cooperated before indictment for 1 year. And I just want to make clear, Mr. Johnson had every interest in trying to apprehend Mr. Jolly because his sole focus was trying to return the money that Mr. Jolly and Mr. Frimpong stole from investors and stole from his own friends and family who were also investors, and who Mr. Johnson himself was an investor. So Mr. Johnson had every interest in trying to cooperate with the government and apprehend Mr. Jolly. And just because perhaps those efforts weren't successful in apprehending Mr. Jolly, who still is, as far as we know, in South Africa, has not been returned to this country to that justice be served, he had every interest to do so. Secondly, and I believe Your Honors point this out, Justice Berner, I believe you pointed this out, Postal Inspector Campbell's credibility is not a sideshow. It is the core element of our criminal justice system to test the reliability and the testimony of especially the lead government witness in a case. Thirdly, Your
How
Honor.
do you respond to the government's, so you heard what I said to the government, that, let's assume I'm sympathetic of the initial
Sure.
decision to limit cross, but then it seems troubling to send fled. And when I asked the government that question, they said, well, that's because the defendant reopened the door to what happened. What is your response to that? I want to give you a chance to respond to
Do you
that.
mean in regards to the overt actions?
To submitting fleeing to the jury as an overt act.
We still believe that was an error, and we think that
But the government says your client reopened the door by discussing the circumstances of him leaving.
we don't necessarily think we opened the door to that. I think that the elements at which we brought that in for, and it's referring to the testimony of Cardbo and of Mr. Johnson himself, it was to show, I think, Mr. Johnson's efforts in cooperating and what he did not know. I don't think that the actual fact of whether Mr. Jolly fled or was permitted to leave was ever addressed or clarified by testimony from those other witnesses.
But I guess your client argued that he was left holding the bag. I mean, another way to say I was left holding the bag is after the other guy fled. I don't know what it means to be left holding the bag without the inclusion because the real bad guy fled, right? Isn't that what holding the bag means?
I think it's, yes, Your Honor. I think in this case, it's dual purpose. I think here, it's that Mr. Jolly fled, of course. He's the person who was ultimately responsible. But I think on the other hand, it's also that Mr. Johnson had no knowledge of any of this and was left holding the bag to be the scapegoat, if you will, or to be the government's easy conviction for something that was otherwise a heinous crime, of which Mr. Johnson knew nothing about. I would just briefly like to address count 7. The issue with count 7 is, and I just respectfully disagree with my colleague's account of what occurred with regard to count 7. It was never articulated in hearing or to defense counsel that the prosecution would be willing to vacate that or release Mr. Johnson from a conviction on that count. So that was not understood to us. Our point of view was that if he was convicted, he'd be convicted on that count improperly.
But they acquitted on that count, so what's the import of the
Sure.
fact that they refused to dismiss it? That's where I get stuck.
Sure, I think the import is twofold. Number one, it's that the prosecution was unwilling to recognize this error and do whatever they could to convict, but also that the jury still convicted on count 6, which was the overarching conspiracy to commit securities fraud claim, of which this count directly related to. And I would just point out that in response to Mr. Johnson's motion for release pending appeal, the government actually stated and recognized that including this count 7 likely confused the jury. So again, I would fall back on the point that given how, and this is in the record, I don't have the J number, but we cite it to it in our papers. And I would just fall back on the point that given the extremely close nature of this case and the fact that anything could have changed the turn or turned the tide for our client, we feel compelled to raise these important issues because anything might have made a difference for our client's case. So I notice I'm just about time. I thank you very much for the consideration and the opportunity. Thank you, Your Honors.
Counsel, thank you for your arguments. Ms. Quattrone, do I see that you're court appointed?
Yes.
Well, first of all, especially in light of Public Defense Week, we would like to thank you very much, as always, and especially this week for your work in this case. The court relies on it to do our job and to ensure the Sixth Amendment rights of defendants are vindicated, so we very much appreciate.
Thank you, Your Honor. I appreciate it.
We'll come down and proceed, greet counsel, and go to our last case. All right, well, again, folks are getting reset up in the courtroom. Our final case of the morning, still morning, is 24-4108, United States versus Samuel Joseph. I think the first person we'll be hearing from is Mr. Carrico. Did I say that correctly?
Yes, sir, you did.
Wonderful. Take a minute to get settled, and we'll hear from you when you're ready.
May it please the court, my name is Tim Carrico, and I represent Samuel Joseph, the appellant in this case. Mr. Joseph was convicted by a jury trial by multiple counts involving guns and drugs. The two convictions stem from two separate arrests, one in Charleston, West Virginia on December 27, 2021. The second arrest in Parkersburg, West Virginia on March 17, 2022. Prior to trial, defense counsel filed two motions to suppress relating to each of the arrests on each separate date. The district court below conducted an evidentiary hearing related to both searches or both arrests and denied the motion to suppress. So the matter went to trial. All the evidence that was seized relating to both of those incidents was admitted into evidence, namely guns and drugs, methamphetamine, fentanyl, and guns. The main issue of contention below concerned the courts. What we contend is the courts incorrect or not giving appropriate weight in its determination. First and foremost, as to the first, I'm talking about the December 27, 2021 arrest in Charleston, West Virginia, and not giving appropriate weight or consideration or findings relating to the police officers, the Charleston police officers' refusal to use their body cams.
Well, that's not illegal, is it? I mean,
No, sir.
there was a long time before we even had body cams. So, you know, it might reflect on their credibility a little bit, but that's about the extent of it, isn't it?
I respectfully disagree to some extent, Your Honor. The court below found that really all the court stated in its findings and in its order was that it may have been wise for the officers to use the body cameras, that it may have been in violation of department policy for the Charleston Police Department, but the court didn't find, and then made one sentence finding that did not find that it rose to the refusal to a constitutional magnitude. And that's basically what the court's ruling was below on it, and that was it. Now, in the case, the officers were questioned. They confirmed that there was in fact a body cam policy, that they were required to wear body cams in connection with any interactions with the public. And the policy, the Charleston Police policy that was cited in the briefs to the court is that preservation will preserve factual regulations of officer-citizen interactions. And Detective Johnson, who was handling this, the lead investigator on the December 27 arrest, was aware of that policy, was questioned about it, and his response was he didn't use his body cams. They didn't use the body cams. The other officer acting with.
Again, what is the legal relevance of any of this, right? The Supreme Court has squarely held, unless you can correct me if I'm wrong, but the Supreme Court has squarely held that violating policy or even violating state law does not violate the Fourth Amendment, right?
Yes, sir.
So the only question that this relates to is whether the district court should have disbelieved the officers as a matter of credibility, right?
Yes, sir.
And that is a topic that is reviewed for clear error on appeal, right?
Yes, sir.
And so what you're sort of doing here is an argument that goes to the jury. You say, ladies and gentlemen of the jury, if these guys are so spotless in their conduct, why didn't they turn their camera on? That's probably how you argued it, pretty much, isn't it?
Well, actually, I was trial counsel. There was previous counsel
Well,
handled
that's
it.
probably how I would argue.
Yes, sir. That is correct. But when you go to, after these decisions are made, all this evidence is in front of the jury, it really doesn't matter. Once the
Well,
court.
no, you tell the jury they should disbelieve when the officers testify to what happened, you tell the jury, maybe that's what happened, but if they're telling the truth, why is there no body cam footage? Maybe you shouldn't believe them when they testify to what happened.
Yeah.
Well, when the evidence is introduced in front of the jury that when Mr. Joseph was apprehended on December 27th, and then he's arrested, he's cuffed, then the bag's seized, then they get a warrant for the bag going to the bag, the methamphetamine and guns are found in the bag, and that's presented in front of the jury. It's open and shut at that point in time.
So can I ask you a question about, go ahead.
No, go ahead, I'm sorry.
I'm gonna switch topics.
No, you go ahead.
Okay. So can I ask you about the abandonment issue? Because for the life of me, I can't figure out why the abandonment issue matters in this case, and I'd like you to help me try to figure that out.
Well, the
Like
abandon-
whether he abandoned or not. So, sorry, let me give you the hypothesis for why the abandonment doesn't matter. So, I don't think there's any Fourth Amendment seizure in this case of any sort until your client stops running and is apprehended by the police, right?
Yes, sir.
Okay. So, and that's long after he's, quote, abandoned the bag, right? Or abandoned or not, dropping the bag has happened by the point that has happened, right?
That is a
As the
disagreement
district
between
court-
Mr. Joseph and.
Let me rephrase. As the district court found the facts.
Yes, sir.
That's already happened. Okay.
The court found that specifically, it determined that Officer Clendenin's testimony was more credible than Mr. Joseph's.
Okay.
And
So at the point that happens, it seems blindingly obvious to me that there is reasonable suspicion of unlawful conduct because we have got A, the tip, B, the officer seeing with his own eyes drug material, and 3, your client's unprovoked flight, which seems highly relevant under Hodari D. So it seems at that point it is clear there is at least justification for a Terry stop at that point, at which point we can keep him until the drug dog shows up. The drug dog shows up, the drug dog sniffs drugs, at which point there is now probable cause the bag contains drugs. Notice how I haven't said the word abandoned at any point. I just don't see why there's any abandonment issue in this case at all.
I believe the argument, Your Honor, would be that at the time that based on the evidence in the case, the officers did not have reasonable articulable suspicion
But
at the
you
time
ignore,
the
but you,
incident-
when you discuss this point in your brief, you ignore the flight. And the flight under Hodari D is deeply relevant, isn't it?
Yes, sir. The flight is deeply relevant. Mr. Joseph admitted in his own testimony when he was initially confronted by Officer Clendenin, as Officer Clendenin stated, he didn't know why, but he took off running.
He took off running, right?
And he says,
And so that plus the officer's personal observations plus the tip seems obviously reasonable suspicion to me.
well, as to the personal observations, the officer they conducted surveillance commencing at 12 o'clock that day. So Officer Johnson conducted approximately 10 hours of surveillance.
I looked through the window of the room, and I saw drug material that is not disputed to have been drug material, and in all that time, one person went in or out of the room, and it was your client, right?
Yes, sir.
How is that not reasonable suspicion of drug activity?
I believe the argument below is that we have the officers themselves, serious credibility issues because they didn't use their body cams. There was no evidence that the body cams did not work. There was no evidence that they were not available, and frankly, Johnson admitted it was available. They just did not use them. It wasn't that the policy wasn't mandatory, that there was a question on that. They didn't use, and you couple that, and then Johnson's asked why, okay, you actually saw, well, secondly, from the record, when he did the knock and talk at 4:30 PM, when he planned to do the knock and talk, he didn't have a body cam. He intended to do that without the body cam, even though he confirmed in his testimony that he didn't have to, because Mr. Johnson, or Mr. Samuel Joseph didn't answer the door, he wasn't there, he didn't use the body cam. But he also was asked questions, why didn't he take pictures of the alleged paper folders, digital scale, and baggies that he purportedly saw? He didn't do it. He's asked, he just didn't do it. Then after that, he did see Mr. Joseph dropped off at the hotel at approximately, I believe, 8:30 PM. And at that time, he followed the vehicle that dropped him off, and it turned out were two females. They stopped the vehicle. He did a full-blown search of their vehicle. And secondly, this is the second contention of violating officer or CBD policy. He did not use a body camera in connection with those conversations with those two females. But he did not find drugs. They were not under the influence of drugs or alcohol. They did not implicate Mr. Joseph in connection with any drug trafficking whatsoever at all, other than stating that he paid $10 for the drive. He lied to them because they told, one of the females told the police officer, or told Johnson, that they dropped him off at McDonald's, and the officer knew that was incorrect, and that it was an out-of-town dude.
Are there any facts in the record who this driver was? It's just sort of glaringly weird when you read the briefs and read the district court. Like, someone gave him a ride and we questioned her, but no additional information about who that is.
I believe her name is in the record, if I'm correct. Her name is actually in the record below from what I've seen.
But it's not like, this is not an Uber or Lyft driver or a taxi or something like that, at least according to anything I read, right? Or we don't know?
No, sir, there's no other information that he allegedly spoke to this person, and he did not activate the camera, which he knew was his policy. So, and that's the issue when you have these sorts of arrests, the reasonable suspicion, a Terry stop. They have the body cams available. It would answer a lot of these questions. I know that per se it's not unlawful, but if it is coupled with bad faith, and
Well, what's the evidence of bad faith here? I mean, what you're sort of doing is arguing to us what your predecessor probably did to the jury. You know, here's a guy that's over at McDonald's doing all this illegal stuff. Why isn't there any film from the McDonald's cams about this? Why isn't there any body cam from the police officers? Now you're gonna believe these guys? That's sort of, you're making a jury argument to us on this.
yes, sir. Actually, I ended up having to try the case below, and I did something I've never done before. With all the evidence coming in, knowing that's all coming in, and Mr. Joseph would not he didn't want to sign a conditional plea agreement and was concerned about waiving any interest. So we tried it, and I didn't contest. First time I've ever done that. Very uncomfortable doing that. Did not contest it. So he still got acceptance of responsibility. I didn't say, he got a 270-month sentence, was a sentence from the court. But with all that overwhelming evidence coming in, all these questions to make in front of a jury, it really didn't matter anymore. That all
Can I
just
ask you
related.
one last question about December, because I have a question
Yes,
about
sir.
March. Is there anything in the record about how much time passes between when the defendant is handcuffed and when the drug dog alerts? Is there anything in the record of what the duration of that period is?
No, sir, no specific on the time period other than the officer explaining, Johnson explaining, and Clendenin explaining what had happened.
But I believe it's in the record that the dog was already there, right? They didn't have him handcuffed in this parking lot and wait for. wait for a dog to show up. The
The
dog was
officer,
there.
yes, sir, that is correct. The Officer Clendenin who arrested, who arrested Mr. Joseph had the dog. He was a patrolman. He was not an interdiction officer, I believe, such as Mr. Johnson was. He
So
was
can I move you to
assistant.
March then?
Yes, sir.
What do I do about the fact that the district court specifically found the stop was not extended to wait for the dog?
Actually, Your Honor,
Judge is fine.
from looking at the record and going through the tapes, it appears that the officer prolonged the stop by his unrelated investigation by 3 minutes. And my understanding from reading the Rodriguez decision, the issue is not really, the issue is, did in fact the unrelated investigation acts prolong it? And the arrest was at 11:05, strike that, 11:01 a.m. in the morning and 51 seconds. That's when the initial stop was made. At 11:03:46, Officer Snyder calls in and asks for a canine. He does not ask for, he does not provide the request for a warrant, driver information, because the driver in that case didn't have a driver's license. He had a driver's
Right,
license number.
so he's not extending the stop at that point. He can't call in a license if he doesn't have the license.
No, sir. At 11:03, he had the license number. He was at the car at 11:03. He had already had the license number and that information. Rather than calling that into dispatch, he called in for the canine first. Now, Officer Snyder testifies he doesn't remember whether he was back at his car yet when he called in for the canine or whether he was walking to his car. But as a result of that, he did not actually call in to dispatch that information to determine whether there were warrants and whether he was a legal driver or had a legal license until 11:05:28. That's a minute and 42 seconds.
Okay, but you said the following happens. He goes to the driver, he gets the license. As he's walking back to the car to call in the license, he just squawks his radio and says, get us a canine. He doesn't break stride. He's still walking. He says, get a canine. He walks back to the car. He then calls in the license. You wouldn't say then he's extended the stop to call the canine, right? Because he's going to have to walk back to the car either way. If he walks and talks at the same time, that's not an extension.
Correct, sir, but that's at 11:03:46, and he doesn't call dispatch until 11:05:28, a minute and 42 seconds later.
But what do I do with the district court finding that he called in the canine while he was beginning to fill out the citation? That's what the district court found happened.
The evidence is at 11:05:28.
So we would say the
Called
district court was clearly erroneous when it found that.
Yes, sir.
Okay.
At 11:14:09, this is 8 minutes and 19 seconds later, at 11:14:09, dispatch tries to get in touch with Officer Snyder to say they got the information. No warrants, which is going to dispel reasonable suspicion, and also the driver, Mr. Williams, has a valid license. So dispatch tries to call him at 11:14:09. He doesn't answer. Now, it appears from the record what he's doing, he's talking to Officer Morris, who works for Metro Drug Unit in Charleston, who tells him at that point in time that, tells him that Mr. Joseph is a drug distributor, and he's aware in Charleston. That's it. But the argument is that extended it, and not until 11:15, because he didn't take the call. He didn't get the information from dispatch until 11:15:30, and then when he gets the information back from dispatch, he walks to the car to give the ticket, and he says at the same time that's when the dog canine person arrived. So the argument is that it was extended by 3 minutes,
Wait, the 3 minute, there was 1 minute when he got the information, then he went back to the car. Where's the extension?
well, he should have called, we contend that he should have called dispatch at 11:03:46. That should have been the first thing he had done, just called. And as a result, he didn't do that. He called for the canine and didn't call in until 11:05. Then the next extension is, it appears from the record, he's on the phone with Morris, talking to Morris about the unrelated investigation rather than taking the call from dispatch at 11:14:09, which is telling him, excuse me, Your Honor, I believe I'm out of time.
No, feel free.
So rather than taking that call, he's talking to Morris, conducting his unrelated investigation.
That was when they called in the information for him to write the ticket, and then he was on the phone with the other guy, and he actually got the information a minute later.
And what about the third party that comes up to the car? Isn't that enough of a reason for the delay?
Well, it's not clear from the record when that actually happened. I think from the record, the only reasonable time that could have happened is after that occurred after he had already called in the information at 11:05:28. When he called in, all this stuff happened, because he was waiting, he did wait, but for the information back from dispatch. And it appears, based on the timing and the testimony, that had to happen after 11:05. So after 11:05:28, that's when I believe they would have dealt with a third party who came up to the car, and secondly, he got on the phone with Morse. But he gets a call back, no question, he didn't take it from dispatch, and they had that information, and then he gets off the phone with Morse.
Thank you, Mr. Carrico. You'll have some time in
Thank you,
rebuttal. Mr. Wolf, we'll hear from you.
Thank you, Your Honor. May I
Not
please-
sure it's going to matter, but your time was starting at 19.
Sorry.
Very good. You can go ahead and start. We'll get it figured.
Thank you, Your Honor, and may it please the court, good afternoon. I believe it's afternoon by now.
4 minutes.
My name's Jeremy Wolf. I'm here representing the United States in this case. Talking first about the December 2021 incident, the district court held a suppression hearing relative to that Terry stop and arrest. And during that suppression hearing, the two officers involved, Johnson and Clendenin, testified. The defendant himself testified. All those witnesses were subject to full cross-examination. The district court had the opportunity to hear each witness's testimony and observe their demeanor as they testified, which of course is an important aspect of a credibility determination that unfortunately doesn't make its way into a transcript, doesn't make its way into the record on appeal. Nevertheless, after that hearing and based on the testimony and the evidence and observing the witnesses during the hearing, the district court found that the officers were more credible than the defendant.
Can I still ask you the question are there any facts in the record about this driver? It's just bothering the heck out of me to not have any idea who this person is or what the circumstances are.
Yes, Your Honor. Well, we got into it a little bit more at trial, but of course, that didn't end up in the record on appeal in this case. But the driver, she was identified. She was not an Uber, as the court was asking Mr. Carrico earlier. She was a private citizen. And this didn't find its way into the record either, but she was interviewed later on by Detective Johnson, and she actually admitted that she was driving him around for drugs.
So can I ask you, do you have any quarrel with the proposition that the fact that there was a policy that required them to turn on their body cams and they didn't is relevant information for the district court to consider?
Relevant or irrelevant, Your Honor?
Relevant.
I believe it may have some relevance if there's a pattern of violations, intentionally failing to
I'm
follow
not saying it's
policy.
dispositive. I'm just asking if you have any quarrel with the proposition that's irrelevant.
No, Your Honor, I don't.
Okay.
I
And
don't.
that it could be used to go, like, I guess I'll say it, if the district court had made an adverse credibility finding to the officers, would it have been improper for the district court to rely in part on the fact they were wearing body cameras, they were supposed to turn them on, and they didn't?
The simple fact of that, no, Your Honor, but I believe.
No what? As in the district court could not have relied on that fact?
I would not have had a quarrel with that.
Okay, thank you.
I'm sorry, Your Honor.
Nope.
But I think, of course, the devil's in the details. Part of the testimony that the district court heard during that suppression hearing was Detective Johnson's explanation as to why he didn't have his body cam on, why he didn't activate the body cam. And the court obviously, of course, the district court was entitled to credit that and apparently did credit that. And I would
Remind
say,
me again what his explanation for that was?
so there was only really one policy violation in play in this case. And that would have been Detective Johnson's admitted failure, to take the body camera from the charging port in his vehicle, put it on himself when he went to approach and eventually stop and arrest the defendant. His explanation was that when he's sitting in his vehicle, he doesn't keep the body cam on, he keeps it in a charging port. And that apparently he knew he was going to get out and approach the defendant at some point, but it was a somewhat hasty decision. Oh, he's in the McDonald's, he's not coming out. We're going to jump out and do this now. he admitted that he failed to take the body cam with him. And I think he was very candid in doing that. Of course, not my opinion doesn't really matter, it's the district court's opinion, but the testimony was very candid because defense counsel was somewhat unclear and expressed some doubt in his questioning as to whether Detective Johnson even fell under that body cam policy because Detective Johnson was working for a drug unit. Detective Johnson candidly corrected him and said, no, sir, I was under that policy and I failed to take the body cam with me. And so his explanation was very candid and, of course, worthy of credit by the district court. And, of course, the district court did credit that explanation, finding the officers more credible than the defendant. I think it's interesting when it comes to the body cam issue, the only disputed matter of fact relative to this incident was whether the defendant threw down his bag during the pursuit. That's it. Everything else was either agreed to or not disputed.
And can you respond to the question I asked of the other side? Why does this abandonment issue matter here at all?
It really doesn't, Your Honor, because even if the defendant didn't abandon his bag, as the court noted, there was abundant reasonable suspicion to stop him. And the defendant didn't challenge a lot of things in this case. The defendant didn't challenge the length or the scope of the Terry stop. He didn't challenge the canine sniff of the duffel bag.
Or that it created probable cause?
Correct, Your Honor. He didn't challenge the search warrant that was issued. So his challenge was really narrowed in on whether this Terry stop was appropriate at its inception, whether there was reasonable suspicion, and obviously there was. So if you credit the defendant's version of events, if you just credit his version of events, that he held this duffel bag all the way till the end, until he surrendered, well, then it's seized right along with him, and the canine sniff happens, and the warrant issues, and we get the same evidence. So I think even if there was an error in the district court's handling of the body cam issue, even if the district court failed to appropriately assign weight to that fact in making its credibility determination, if the court, for the sake of argument, let's say the district court clearly erred in finding the officers more credible, clearly erred in finding the defendant abandoned the duffel bag, it'd be harmless error because we end up in the same place.
Can I bring you to March? So your friend on the
Yes,
other
Your Honor.
side says that basically, I mean, I understand he's reluctant to say it, but I think their argument is the district court was just clearly erroneous in concluding the stop wasn't extended. You heard, could you just, what is your response to the account that the district court gives does not match the time on the video? That's essentially what I view, or the audio or whatever. He just says the district court's version of when things happen does not match the timeline of known events. Would you just respond to that?
Well, that timeline wasn't really challenged at the suppression hearing. So I think there's indisputable evidence that the timeline was correct. And the district court found that there wasn't an extension, that Sergeant Snyder never diverted from the task necessary to issue the citation, that the citation wasn't issued by the time the canine arrived and indicated on the vehicle, that this stop took around 15 minutes total, that there were various impediments to Sergeant Snyder going through with the mission of this stop. First of all, being that the driver didn't have an ID with him. Second of all, the third-party male intervening. And so there's nothing.
Did the third-party male intervene before or after the citation was written?
Before, Your Honor. I think it was unclear at what point during the timeline it happened, but Sergeant Snyder testified that of course, he was unable to work on the citation while he was dealing with the third-party male. So he got up out of his vehicle, presumably left the citation and all the documents in the car and went to deal with this guy, and that took a couple minutes. But that happened before the citation was completed, because the citation wasn't completed until after the canine indicated. And so the district court's findings on that issue were also not clearly erroneous. And going back just briefly to the first incident, you know, Officer Clendenin was the only person, other than the defendant, who observed the pursuit, who could have offered firsthand testimony about the abandonment, whether it happened or whether it didn't. The defendant, or counsel, never asked Officer Clendenin about whether he had a body cam on, why he didn't. The only question that was put to an officer on that issue was to Detective Johnson. Counsel asked Detective Johnson, do you recall whether Officer Clendenin was wearing a body camera? And Detective Johnson said, not that I recall. But Officer Clendenin was never asked that, so we don't know why he may have not worn it, why he didn't have it with him, why he didn't activate it. I can tell the court that I know there wasn't a body cam video from Officer Clendenin because I checked before I charged the case, and there wasn't one. But that question wasn't asked, so the court never got a chance to hear his explanation as to why he may have done that or worn the body camera, why he didn't. And so it's certainly not clearly erroneous for the district court to not discount an officer's credibility based on something that he's not asked. And so based upon all this, if there are no further questions, I would ask the court to simply affirm.
Thank you.
Thank you, Your Honor.
Mr. Carrico, you've got some time.
Yes, just briefly. Your Honor, as to your point, your question relating to what is the significance, or is there any significance of whether there was abandonment? And I believe what's clear on the record is that the officers, once Mr. Joseph took off running and went into the other lot and when he's apprehended, he was arrested for fleeing and obstruction.
But he's not arrested until they, right there, I don't know if that's Hodar D, right? You're not seized until you, it's not just enough to say stop, it's not, they have to catch you, right?
Yes, sir.
Okay.
And once Mr. Joseph started running, the officer reasonably would have had reasonable suspicion at that point in time.
Right.
He had reasonable suspicion to detain him and talk to him
Right.
to dispel or confirm. However, based on the testimony of Officer Johnson, they arrested him at that point in time. He was arrested. Judge Johnston, or the district court in his findings, determined, well, this was really just a Terry stop. It wasn't arrest, but it was arrest, and that's what Officer Johnson testified to, that he was arrested for fleeing and obstruction at that time.
But hasn't the Supreme Court told me that why an officer believes they arrested someone or when they believe they arrested someone does not control when, as a matter of the Fourth Amendment, they arrested them?
Yes, sir. The other point I would like to make is in connection with the information. The information that Mr. Moore, or that relates to this arrest would have been the information that we believe that the information that Officer Morris provided to Officer Snyder in Parkersburg. So if in fact.
Sorry, is it, I just want to make sure factually I'm tracking you. Is this the December or the March incident we're talking about right now?
No, well, I'm talking about the December incident.
Okay, thank you.
And information relating to that arrest would have been provided by Officer Morse to Officer Snyder in Parkersburg when he was on the phone. So if the court were to find that at that moment in time, one would think that arguably he would have extended the stop at that point in time once he got that information. But our argument is that came after the fact, and they should have been out of there before the K-9 got there. Thank you, sir.
Thank you, Mr. Carrico. Mr. Carrico, I noticed that you're court appointed.
Yes, sir.
The court, we thank you, especially given the context of being public defense week or month. I don't remember if it's week or month, but more so than even normal, we'd like to thank you for your work on this case, both it sounds like in the trial court and here. The criminal defendants rely on it, the court relies on it. We very much appreciate your work in this case. We will come down and greet counsel and then adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.